Good morning. We're going to call the February 20th public hearing of the General Law Committee to order. It's 12:05. We are going actually do the rankings. Have any comments? We're good? Public hearing. Okay. And then we will go. Number one, Justin Gargano. Just a reminder, you have 3 minutes for your testimony. Justin? Okay. Next, Sean Jeffrey from Hartford Healthcare.
Good afternoon. Excellent. Good afternoon, Senator Maroney, Representative D'Agostino, Senator Fonfara, Representative Brown, Senator Ciccarella, Representative Bertigliano, and the honorable members of the General Law Committee. My name is Sean Jeffrey. I'm a licensed pharmacist, practicing in Connecticut for over 26 years. I'm also a professor of pharmacy practice at UConn and director of pharmacy at Hartford Healthcare's Integrated Care Partners. I live in Branford. Here to support Senate Bill 133. So over the past several years, the General Law Committee has helped to pass significant legislation advancing pharmacist roles in Connecticut. And Bill 133 adds to this progress by advancing the role of pharmacy technicians. Importantly, creating an advanced pharmacy technician will improve efficiency and workflows, can reduce dispensing errors, and as noted by DCP, this could help alleviate some of the burden from pharmacists who are struggling to fill prescriptions, administer vaccinations, and provide consultation and guidance to patients. Connecticut is not blazing new trails with this bill. In fact, the responsibilities outlined in this bill for advanced pharmacy technicians have existed in 21 states already. Under the leadership of drug control and with the input of Connecticut's practicing pharmacists and community health systems and long-term care pharmacy, SB 133 creates a feasible and achievable pathway for technicians to advance their careers. Advanced pharmacy technicians will be rewarded with greater job satisfaction, opportunities, and pay. And it's important because it's estimated that nationwide there's going to be a shortage of over 30,000 pharmacy technicians in the coming years. That's what makes this all the more important to utilize our skilled workforce to its maximum potential here and create the opportunity here in Connecticut so those with these advanced skills don't look for employment elsewhere. And additionally, creating an advanced pharmacy technician is another important evolution in the practice of pharmacy in Connecticut. While the safe dispensing of medication will always be the priority for pharmacists, we need to position the pharmacy workforce for the future. Pharmacists play an increasingly important role in care delivery across the continuum of care. Having an advanced technician can enable pharmacists to greater focus on emerging patient care opportunities. And for example, we are about to experience significant changes in healthcare as artificial intelligence helps augment practitioners. As Senator Maroney can attest, AI has tremendous potential to make healthcare safer, more efficient, and potentially more equitable. UConn School of Pharmacy is actively exploring how the process of medication reconciliation, a job that is largely filled by pharmacy technicians, can be improved with the use of AI. So this bill will help pharmacists and pharmacy technicians pre-position themselves for new roles and new responsibilities. So passing SB 133 will help the profession of pharmacy be able to adjust to these changes more quickly. We can use this window to build the workforce that we need here in Connecticut and keep them in Connecticut. And I thank the General Law Committee for considering this legislation, for the Department of Consumer Protection and Drug Control Division for crafting this bill in conjunction with the pharmacists across the state. We look forward to further collaboration and to remedy any concerns there might be regarding the passage of this Senate bill. It's going to keep jobs here in Connecticut, increase access to healthcare, improve health equity for all of Connecticut's residents. Thank you very much.
Sean, thank you very much. And thanks for your help over these last couple of years with collaborative practice and many of the other bills. You and, of course, Rod Marriott from DCP have been tremendously helpful, and I feel we've accomplished a lot. One thing I've noticed is there was testimony submitted in opposition to the bill. I don't know if you could address the points there.
Yeah, I'm happy to do so. And I appreciate the perspective that others have brought to this legislation. And I think that the importance here is that we have the need to advance our roles with technicians. So the concept is an important one to continue to advance. The language, we're happy to work with anybody around any modifications that we need to address their concerns with wording or language, but this is a very important concept that we want to see advanced. And as I mentioned, this is not a new concept. This is in various ways, shapes, or forms been in conversation in Connecticut for probably 20 years.
Do you know how many other states already have something similar?
There's approximately 21 states that have changed the roles and responsibilities of technicians to allow them to practice at these advanced levels.
Start from the outside in. Representative Yacarino.
Thank you, Mr. Chair, and thank you for your testimony. As I'm reading through the proposed legislation, I don't see anything about training for the technicians. Is there rigorous training? I mean, it's very important to prescribe these drugs properly. And then also, is it all class prescriptions? Like, is there a certain class where they cut off, where they cannot?
Yes,
Uh,
so if I can, the training process, the qualifications for the pharmacy technicians, they will need to undergo additional training. They're going to have 3 years of experience. They're going to have a validation process to assure their accuracy in dispensing. So there are steps that are going to be in place to make sure that these are truly advanced technicians. And to my knowledge, it's not going to be restricting any particular class of medication.
Thank you for that answer. Obviously, it's extremely important when you're prescribing, certain types of drugs. But I don't see enough language as far as, I'll listen further as far as actually the strength of the training. So I'll continue to listen. But I would think, well, you're at the hospital, would there be any liability for the technician? Because I know that if there's something was to go wrong.
So just so that I can understand your question, you're concerned about liability for a technician that may make an error in the course
Yes.
of their practice? So in the course of their practice, just like in the course of a pharmacist's practice, if there were an error to occur, obviously that would be something that would be investigated to make sure that there wasn't anything that was maliciously done. But assuming that the error is a simple error, they would fall under, I believe, the hospital's malpractice.
All
But
right.
I will defer to others who can further clarify that.
One last question, Mr. Chair. Who does the training? Who would provide the training? Would it be a school or the hospital, the pharmacy?
So the pharmacy technicians now will be certified pharmacy technicians. So there are, for example, the Pharmacy Technician Certification Board is one pathway that they can receive this certification. The training that they would get is often on-the-job training. So those would be the two pathways that they would attain this advanced training.
Thank you. And then just clarification, they're not prescribing, they're just filling prescriptions,
Correct.
correct?
Correct.
And it's under the supervision of the pharmacist, so there's a final check on everything as well. Is that what I understood from the legislation? Or I know there are multiple sections, so there's the section with the blister packs where that had to be checked.
Correct. What I would like you to, if we could, defer those questions about the actual tech check for testimony from Dr. Abdelghani and Hatfield, who are going to be able to talk a little bit about more on how that is operationalized.
Okay, great. Thank you. And Senator Kissel?
Just trying to follow protocol with ranking members. Good afternoon, Professor. I guess my question is, in your testimony, you had spoken about medication reconciliation, and I'm not really sure what that is. I'm sort of guessing that maybe that's how different prescriptions interact with the patient or with each other when administered to the patient. And I would think that responsibility would be with the physician, not the pharmacist. And I'm just wondering, am I just off on a wild goose chase regarding that, or how does that work?
Thank you for allowing me the opportunity to clarify that. So medication reconciliation is the process by which we try to understand what medications you might actually be taking. And while that sounds like a very simple process, it can actually be very difficult. I'll give you an example here. If you were to come to the hospital emergency room unconscious and we don't know anything other than your name, we may not be able to determine which medications you're taking based on what system you see your physician in, which pharmacies you go to. So it's routine that in the process of transitions of care, in the process of somebody coming into the hospital, being discharged from the hospital, going to their provider's office, that at every touch point, you should go through the process of reconciling somebody's medications to make sure there haven't been changes that are made that the provider or pharmacist is not aware of. And that process tends to be a kind of a labor-intensive process of sitting down, looking at different sources of data, trying to reconcile the list to come up with the best possible medication history. And that's a role that pharmacy technicians have often taken, especially in like emergency rooms. We'd have a pharmacy technician that might be doing the med reconciliation for somebody who's coming into the emergency room. So they're not making decisions based on potentials for interactions or the appropriateness of the choices of the medications. What they're doing is they're teeing up for the providers the list of the most accurate likely medications somebody's taking.
I really appreciate that. That's very helpful to clarify what's going on. So the prescribers, the physicians and the pharmacists themselves still have the responsibility, but it's these other folks, the technicians that are compiling the information. So I have another question too. Sometimes I think when we've put forward legislation to try to get our arms around folks that are sort of shopping around and getting drugs from different places, I had thought that we were trying to sort of stem people sort of doing that to try to get disproportionate amounts or illicit drugs for themselves. They might be addicted or have other issues. And I didn't know if we had like a central database with this information, or when these technicians try to put together this information, where do they go? Does like CVS have a database? Does Walgreens have a database? Does Hartford Healthcare have a database? Or what's the world look like right now for the people in the state of Connecticut?
Great questions. This is actually a topic that's very near and dear to my heart. So for the sake of controlled substances, the state has a prescription drug monitoring program. And any controlled substance that's dispensed from a pharmacy in Connecticut is reported to that prescription drug monitoring program that's overseen by the Department of Consumer Protection and Drug Control on a daily basis. That portal allows clinicians like those at Hartford Healthcare to be able to look at those dispensed medications within their electronic medical record. So it's a very easy process to be able to determine, to your point, is somebody shopping around for potential medication? Now, that portal, that information could be accessed by a technician if they're given permissions to be able to access that within the EMR. The other piece, though, you asked about where does this data reside? So prescription data is inherently disaggregated. It's in separate silos. So a community pharmacy has its own record of what it has dispensed. The doctor in their electronic medical record has their list of prescriptions that they've ordered for a patient. But it could be that the prescription was ordered for you, you went to the pharmacy and you decided not to get it. So in that case, the EMR will show that there was an order, but there's no corresponding fill from the pharmacy. This is why the whole process of medication reconciliation is very important to try to get right. So the hospitals, the health systems, they have in their electronic medical record a list of what's been dispensed. The pharmacies have their lists of what's been dispensed. And some of that is reconciled through third-party vendors that help to make that communication of the data flow. But in general, it takes the effort of a lot of individuals to be able to reconcile those meds into one true and accurate best possible med history.
Wow, wow, really complicated. And one last question with the indulgence of the chair. And is this data protected by HIPAA?
Yes.
All right. Thank you very much. Thank you, Mr. Chair.
Thank you. Are there any further questions? If not, thank you very much, Dr. Jeffrey.
Thank you.
Mr. Clerk, if we could go back and see if Justin Gargano is online.
Yes, Senator Maroney, Justin is online.
Okay, great. Justin, it's your turn to testify. You get 3 minutes. Please start by stating your name.
I'm putting them in the meeting right now.
Okay.
There we go. Can you guys hear me fine?
Yes, we can
Um,
hear.
Great. Good afternoon, esteemed and honorable Chairman Maroney, D'Agostino, Vice Chairs Fanfara, Brown, the incomparable ranking members, Rotigliano and Ciccarella, and all the members of the General Law Committee. My name is Justin Gargano, and I am the CEO and founder of Thimble Island Brewing Company located in Branford. I'm here today to speak in opposition of the proposed bill 5149, primarily section 1. This proposed bill would greatly reduce the ability for craft brewers to do any business in the state by limiting their sales only within a 5-mile radius of their production facility and only allow them to sell kegs into bars and restaurants and forbid them from selling into package stores. The current beer manufacturer permit already allows for statewide distribution for products produced by the manufacturers as its own wholesaler. The proposed language would also be a major step backwards and would force beer manufacturers to be required to sign up with a wholesaler if they wish to sell out of their bubble. I'm sure the committee didn't intend for this language to have this effect, and I'm asking for this to be reevaluated. The Brewers Guild originally approached this committee for change around the current beer franchise law that would remove the boundaries of a single territory assignment of a wholesaler and allow for dual multiple assignment if the beer supplier is producing less than 60,000 barrels per year. This change will be more in line with the rest of the alcohol market, like wine and liquor, who enjoy this benefit. I understand that when this law was put in place in the early 1970s, the state did the right thing to protect wholesalers from big business. However, over the last 40 to 50 years, the tables have turned, and the beer wholesalers have enjoyed this benefit for far too long. This law is anti-competitive and does not allow for business to be in control of its own destiny. I mean no disrespect to this committee when I say this, but for lack of a better term, the wholesalers have enjoyed a state-sanctioned monopoly that the rest of the food and beverage wholesale industry does not. I am sympathetic to the fear the wholesalers may have around this change, and it should be noted that our request is not going to materially impact their bottom line. The problem isn't going away, and eventually will need to be dealt with. I'm asking for this committee to seriously reconsider the original proposed language and do the right thing by giving all parties a level playing field. Thank you for your time today for allowing me to speak. I'm happy to answer any questions the honorable committee may have.
Can we get you to maybe just get a little closer to your microphone when you speak?
Sure.
I'm just a little trouble hearing you.
Apologize.
You there?
Yeah, I'm here. Can you hear me?
Yeah, maybe a little closer to your computer or your mic. You're sort of distant and muddled, but I think I got the gist of your testimony, at least the first part, and there's some other written testimony along these lines. And I'm the committee's intent with respect to section 1, to be clear, is to add a very small exception to the current franchise laws that would allow our Connecticut manufacturers, our 3016 beer manufacturers, to distribute directly to and we're going to change the language, but make it clear that it's to a restaurant, for example, a permittee within that 5-mile radius, and not shrink or otherwise alter the current existing architecture with respect to distribution and your contracts with manufacturers. So I'm not sure if certainly if there's a problem with our language, we will correct it to make what I just said clear. And we've already told folks that we intend to make clear the fact that the only distribution that section 1 would permit would be to existing permittees who can sell alcohol, i.e. restaurants. The concept here is, the restaurant's short a keg on a Friday night. Your distributor who you've signed up with can't get it to that restaurant in time, or fail to get kegs that week. Whatever circumstance that occurred, that narrow circumstance that occurred, would allow that sort of self-distribution by the manufacturer to the restaurant in that limited circumstance, in that limited geographic area. I understand the wholesalers have an issue with that, and we're going to hear from them. But from the beer manufacturer's point of view, I'm struggling to understand what the objection is. I would expect that the guild supports this, but if the beer manufacturers are going to tell us they don't want what I just described, then that's fine. Again, if there's an issue with our language, and I don't see any looking at it, that somehow obviates or negates the existing statutory structure. So I just want to clear that up. Have I answered at least your concern on that issue with respect to section 1?
I think it answers this, hopefully you can hear me if I shout a little bit here, but it answers the question around maybe that the language needs to be reevaluated to offer some flexibility. But I believe that the original proposal that we were trying to go for seemed like it kind of got muddied into this type of conversion. And forgive me, I'm new to this process. I'm sure this takes time. This is new from my perspective, but I do know that the original request was to reevaluate the actual franchise laws themselves. And I'm assuming this is a step into that direction, and I can appreciate that, but it still is pretty limited. And the 5 mile radius, I think the large concern that we had there is that it was actually going to collapse basically people's ability who are under self-distribution. And to be clear, I am not. I am with a wholesaler, and so they would not be able to sell past a certain boundary.
Yeah. So again, just to be clear, well, first of all, this is the committee's proposal with respect to franchise laws, and it's going to be met with some serious opposition, even though we're talking about a very narrow exception. We'll hear from the distributors later on that. The committee as a whole is not adopting anything further with respect to their franchise laws, and I don't expect that we will coming out of this meeting or at future meetings, but I'll wait to hear from other committee members on that. But with respect to this particular provision, section 1, I hope I've made the committee's intent clear, and to the extent that we need to clarify the language, and as I said, we're going to clarify the language with respect to the recipient of the distribution, but it at least as I read it as drafted, it does not undermine any other existing rights and privileges on both sides with respect to the distribution laws. So I want to be clear about that. Yeah, Representative Tigliano.
I just a quick question, because you brew at Thimble Island in Branford, correct?
Correct.
Do you see any value? You've given your beer to a distributor who sells the beer. The way it's written, the way I read it, I'm sure the chairman reads it. If you had a restaurant within a 5 mile radius of your facility in Branford that needed a keg on a Friday night at 4, the way I read it, you could run it out to them or sell it to them directly. It doesn't change the distributor that you signed up with for the beer. It just gives you the ability to self-distribute, if you so choose, to somebody in your immediate area. It was a request by the Brewers Guild, and I didn't know if Thimble Island, if you see any value in that proposal.
Any step forward in getting towards dual assignment is value to me. And I think it's value to the Brewers Guild as well. But it's not a perfect solution, and these things do take time to get to a perfect solution.
I hear you. Just to be clear, though, this is not dual assignment. The way it's written, it gives you the ability right now to direct to a consumer in your immediate area of your manufacturing facility. If you think there's no value in that, then that's
I honestly don't
look at
think
me and say, I'm not running any keg out to anybody on a Friday at 4. No, I don't need this. So that's why I was asking the question.
Yeah, I mean, it's the wholesaler's responsibility to be fulfilling those requests, right? I mean, that's the value of having this rule in place for them. So I mean, I don't see this as like a major value and from my perspective. Like at the end of the day, if a customer needs something, it's an all team effort, an all hands effort to get it to them. And how the billing occurs, it's to me doesn't matter if I'm getting paid for it or if they're getting paid for it.
I appreciate, Mr. Chair, you let me chime in.
Sure, of course. Other it's Senator Cohen online, and then we'll get Representative Yaccarino. Senator, you there?
Yes, thank you, Mr. Chair, and thank you, Justin, for being here. You are one of several constituents that are craft brewers, and I've been hearing about the limitations of the distribution and manufacturer's permits for quite some time, and just wondered if you could clarify a couple of things. I understand from the chair that this is a very limited piece that would allow the brewers to self-distribute should there be an issue, sort of 11th hour, somebody needs something, run it over. But I wonder if you could speak to, just so the committee is aware, I know this is something that we've discussed before, but I wonder if you could just explain what the limitations are in terms of that wholesale contract that many of the brewers have entered into with the wholesalers. Are there places that your beer just simply isn't distributed to because the wholesalers don't go there, or they can't supply there, where this dual distribution or self-distribution would be helpful? Because from what I understand from the brewers in the district, including yourself, is that there is a place, and it sounds like the wholesalers would argue this is not the case, but there is a place for coexistence between a contract on the wholesale side and some self-distribution. So I wondered if you could just talk to that a little bit.
Yeah, so I mean, the clear, yeah, so I definitely can. So I think what we've seen over the last few years is that there's been a reduced amount of accounts that are actually being serviced throughout the state of Connecticut, depending on individuals' territories. And my belief is, and from the data that I have, and I'm also from other large suppliers or breweries in the state that I've talked to, are also experiencing the same things with wholesalers, is that basically there's increased operational costs and there's a change of accounts of like how their classifications are and what the service levels are. So what we run into a lot of time is that we're basically losing sales in specific markets because the wholesalers are not actually satisfying them. It is not a 5-mile radius issue. It's a state issue. And it's a classification issue that actually has to do with around like how wholesalers will say, hey, what's the value? How much revenue are we making per this account per year? Are they hitting the minimum delivery that's required, which is actually financial driven? And it's like, are we going to actually then deliver anything to them? So, there's a negative impact based on from a marketing perspective in making products available while we're under limited contracts with them. And what we were asking for initially is like a way to coexist to fill those gaps in. So the 5-mile radius component of it doesn't really fix the issue. And it's not if just a bar runs out of something and it doesn't meet their window or delivery time period. It's a larger issue than that.
So it just sounds like you're not meeting your full sales potential, which obviously is concerning from a small business standpoint. We certainly want to see craft breweries reaching their potential. I've had a couple of them close in the district as well, and I wonder, what part some of this plays. Certainly, we have some limitations with respect to the manufacturer's permit as well. I mean, are there other things that could be helpful for the committee to examine beyond dual distribution for our craft brewers throughout the state?
Yeah, I mean, that's a good question. So I would state that if a wholesaler gets to enjoy the right of a single territorial assignment on their beer, then they should probably be required to deliver to any location within a certain time period.
Okay, that's helpful. Thanks so much, Justin, and thank you, Mr. Chair, for the indulgence.
Thank you, Senator. Representative Yakarina.
Thank you, Mr. Chair. And Senator Cohen asked a couple of my questions, but I do have one question for the gentleman from Stony Creek, or maybe to the chair of the committee. Why the 5-mile radius? If you're at a farm brewery, middle of nowhere, you're going to be outside of the 5-mile radius. I don't know how that's going to work. You're basically, you're left out of the equation.
Yeah. I mean, look, I don't think it's any secret to anybody here that this discussion is preaching at the choir, at least with respect to this representative. I think generally that the statutes and our regulatory scheme is it needs to be modernized and is unfortunately tilted heavily in favor of the beer distributors who, when you sign up with them, you're basically an indentured servant. You can't get out of those contracts without just cause. Dave, I would do statewide if I could like that. But I've tried before at this committee, and we're going to hear from the beer manufacturers. We're going to tell you that it's going to cause them to lay off all their employees if we do that. So I'm all for it. But this very narrow exception of 5 miles was something that we thought would at least be we could at least put out there, discuss, people could at least understand it within those limited circumstances. It wouldn't, unfortunately, deal with the situation that you've described, but so be it.
I'm not done. Thank you. Thank you for the answer. I will say the beer distributors have a lot more on their plate. They have to, many employees. So let's be fair to the distributors. They do a lot of service for our state. It wasn't about pitting each other against each other. I just don't know if it's really the fair, let me finish, the fair policy. When you're a local craft brewer, you have a specific niche and you should, as a business, work off that niche. So all I'm saying is the 5 mile, I think that should be pushed aside. But the distributor has a lot of weight on their plate for paying people, distributing beer, distributing spirits. So I'm not trying to have a turf war between the two of them, but I think they should be able to try to work this out. But the niche market has their niche. And we have to remember that also. No disrespect to the niche market.
Again,
That's all. I just
from
wanted
my
to-
perspective, you're preaching
Yeah.
to the choir. These are sophisticated commercial entities that should be able to contract, and the state should not be putting its thumb on the scale in any respect. And we are. The statutes say you can't get rid of a beer distributor unless you show just cause. You got to go through a hearing at DCP. You got to bring an attorney. You got to put down your paperwork. Then there's an appeal process. I would let commercial properties contract exactly the way you just articulated, but that's not what we do. So that said, look, I think we're open if committee members want to tweak this language. But there's a lot more testimony to go on here. We're going to hear from the distributors. They're here. They have their concerns, which I understand are valid. They want to preserve the 3-tier system. We're going to hear from other manufacturers. With respect to the other manufacturers that are waiting to testify, though, I hope we've clarified at least what this language does, because there seemed to be some confusion in the written testimony that was submitted, this gentleman among them with his testimony, that it seemed to be that they thought that this language somehow was eviscerating the existing structure. Again, it was meant to be a tweak to the existing structure. And I think it is. So I just want to make sure that that's clear going forward to everybody who's testifying in terms of what this language
That's
does.
fair enough. But I'll finish with this. I will say the distributors, and I worked at one when I was a teenager. They provide a lot of jobs that pay really well. So we have to keep that in mind. Thank you.
Other questions or comments from committee members? Online? MJ, anybody online? We're good?
Nobody online, Mr. Chairman.
Okay, all right. Thank you for your testimony.
Thanks.
Rachel Diamond from the Connecticut Brewers Guild. We'll continue the discussion. Rachel, are you here or online? Online.
She's not online anymore, Mr. Chairman, so we'll skip and come back, please.
All right, let us know when we've got her back. Mr. Nathan Tinker from the Connecticut Pharmacists Association.
Yes, he is online, Mr. Chairman. I'm letting him in right now.
Great, thank you, MJ.
Good afternoon. Senator Maroney, Representative D'Agostino, Senator Ciccarelli, Representative Patigliano, and honorable members of the General Law Committee. I am Nathan Tinker, CEO of the Connecticut Pharmacists Association, and I thank you for the opportunity to speak today in support of SB 133, an act concerning regulation of prescription drugs and related professions. Over the past several years, an enormous amount of attention has been paid to pharmacy-related job satisfaction and well-being, including concerns of pharmacist burnout and attrition. Among other benefits to patients and practitioners, SB 133 offers the opportunity to address some of these well-being concerns by reallocating pharmacists' time spent dispensing medications to performing patient care services. SB 133 builds upon the training and experience of Connecticut's pharmacy technicians to create an advanced pharmacy technician, APT license endorsement, which will enhance and optimize patient care services delivered at all pharmacies, including administrative and supportive tasks for pharmacist-provided patient care, and will allow pharmacists to more effectively and efficiently provide for patients' medication-related needs. Appropriately, SB 133 assures that APTs are rigorously and robustly overseen and regulated, including the requirement of multiple years of experience, frequent quality assurance testing, and regular re-endorsement. Likewise, SB 133's creation of the professional title of pharmacy clerk assures a clear differentiation among pharmacy support roles, but also establishes a clear and compelling career ladder for pharmacy support staff and technicians with the potential of progressive income and professional development growth. The elements of SB 133 are neither novel nor untested, and forms of advanced pharmacy technician capabilities have been in place in state law across the U.S. for some 40 years. Both the Connecticut Pharmacists Association and the Connecticut Society of Health System Pharmacists support the passage of SB 33, and we encourage you to support it as well. Thank you.
Thank you very much. Are there any questions? Representative Ackert, then Representative Vitigliano.
I just had a quick question because we're having a discussion here. Ultimately, if this tech person makes a mistake or does something wrong, it's ultimately the responsibility of the pharmacist. It's the pharmacist license that's in jeopardy under this scenario.
In virtually every situation, the pharmacist is the one who's responsible at the end of the day for the activities of the technicians and the rest of the staff who are working under them.
Are they allowed to touch every drug in the pharmacy? So even if, say, it was a prescription for an opiate or something like that, can a tech, are they allowed to touch every drug?
I believe so, in terms of a limited scope of what they can do within that. I would defer to one of our pharmacists who will be speaking later with more specific reference to that. But the technician has the capability to do has a very conscripted format of work that he or she can do under the pharmacist's supervision.
Okay, thank you. I think the person is shaking their head yes in the front row. So thank you, Mr. Chairman.
Representative Ackert.
Thank you, Mr. Chairman, and thank you for your testimony. Just, can you give me, since I'm not a pharmacist, don't play one anywhere, but what is the structure now in a pharmacy now? Because I look like we're adding new positions or clarifying what the job, what is the structure now from my knowledge?
So currently under Connecticut law, a pharmacist can oversee two pharmacy technicians in a retail or community space, or three in a institutional or hospital space. That can be added to during the winter months to add an immunizer technician. And under certain circumstances, that number would be waived by the Pharmacy Commission if there is a particular and a special need to have that ratio waived. This law would actually, the advanced pharmacy technician would be a one-to-one relationship with a pharmacist and would not count against the 3-to-1 or 2-to-1 ratio of the that's currently under technician law.
Okay, and thank you. And then there's a clerk position I see. Is that a new? I see clerk in here.
Correct. That is new. That would be an additional title that does not have the authority to do anything other than the duties registered there, which includes cash register, et cetera. That does not have to do with fulfilling prescriptions. It does not have to do with moving drugs and so forth around. In fact, it is specifically separated from that as a role within the pharmacy, so that you have clear differentiation in the roles of the various workers working in the pharmacy.
Thank you. And you mentioned, so these would be DPH registered or licensed?
DCP.
DCP.
Protection.
Okay.
Drug control.
Thank you. That's right. Pharmacies are under. So thank you. Thank you.
Thank you, Mr. Chairman.
Thank you. Are there, Senator Kissel?
Thank you very much, Chairman Maroney. I appreciate the questioning by Representative Ackert, and I'm just wondering, I sort of understand the push towards this new technician responsibility and role and the one-to-one relationship. Why at the same time are we sort of shifting out this clerk position? What's the big push to have this other aspect?
Well, I think what it does is, as I mentioned in my testimony, is it creates a clear differentiation between the roles in the pharmacy. There are some states where they do not differentiate at all between technicians, clerks, and so forth. And so someone who might be working the cash register, for instance, flips over their name tag, and suddenly they're a technician working behind the bench with the pharmacist and back and forth. I think the intent here is to make it clear the roles within the pharmacy, who is responsible for what specific duties within that, and how then a young employee, for instance, can see a career path through that system into advanced opportunities.
So when I go to the pharmacy and I'm standing in the line, I see people and it's really that point of contact between the consumer and whoever's working the register that goes, gets the drugs, comes back, and they check the people out and they ask some questions. And that person at the register seems to be very informed. If we now sort of cull out someone to just be and I hate to say just, but a clerk, they may not have the pharmaceutical background or the education to be of any help at all. So now all of a sudden, I'm looking, if we proceed down this road, it might be helpful for the business, but I'm not so sure how does that benefit the consumer who interface with that pharmacy is really the point of contact where they get the drug, their prescription, and pay the funds, the copay, or however that transaction takes place. If we interpose this person that really doesn't have the educational background to assist in a discussion about what that person is getting.
I'm sure that as this moves along, the regulations around this would become very clear on that. I do not want to see any situation where the consumer is in any way underinformed or misinformed or misdirected because of a particular connection with a person at the counter, and ensuring that that is not the case will ensure through training, education, etc., that that does not happen.
Well, I appreciate that was sort of a punt as an answer from my perspective. But one of the things that I think is so great about our committee and working, and we oversee the Department of Consumer Protection, is I always view like one of our major roles is consumer protection. I see this as a benefit with the technicians. I understand this medication reconciliation. I understand the benefits to that. And I think that's very complex and it's difficult to get our arms around that. But sort of like cutting out the clerk, I don't know. I don't see any huge benefit to the consumer regarding that aspect of this bill. So I'm happy to continue listening to testimony this afternoon, but that's an area that's a little foggy for me. So thank you for your testimony. Thank you, Mr. Chair.
Thank you. Mr. Clerk, are there any questions online?
None online, Mr. Chairman.
Okay. Thank you very much for your testimony.
Thank you.
Next, Christine Dorchak.
Actually, do we want to see if Rachel Diamond's available online?
Yes, chairs. Rachel is not online yet. Christine is online.
All right, let's go to Ms. Dorchak then. Thank you. MJ, you put him in the room?
Yes, Mr. Chairman, she is in there. I see loading.
Christine? Can you hear us?
Yes, I can. Thank you so
There
much.
you go. You're there. Welcome.
Modern technology. Co-Chair Maroney, Co-Chair D'Agostino, Ranking Member Ciccarello, and Ranking Member Rutigliano, and all the members of the committee. My name is Christine Dorchak, and I'm the President and General Counsel of Greyhound Protection Group, Grade 2K USA Worldwide. We work to pass laws to protect greyhounds and promote the adoption of ex-racers. And I thank you so much for hearing my testimony today in support of Senate Bill 132. And I'd also like to thank you for your unanimous support of the measure in committee last year. I appeared before you with my greyhound Gina, and that was just a wonderful day for the dogs. I've since lost her, so she's with me in spirit today. In any case, that's a little painting I did of her just above mine. So there are many problems challenging our lives right now, many hurdles before us, and these include acts of cruelty to animals. Thankfully, cruelty to greyhounds is something that you have the power to prevent. This humane and timely measure before you repeals the statutes authorizing live dog racing and allows the law to catch up with reality in Connecticut. Commercial greyhound racing is a very old activity. It was introduced in the Depression era, and it wasn't until 1976 that Connecticut decided to give it a try. Well, it was a failed experiment. And as other states began to learn, dog racing fell out of favor and really went into catastrophic decline beginning in 2001. 46 tracks closed down, and now only 2 remain nationwide. And there's a reason for this. The humane issues that face greyhounds are well known. They are subject to extreme confinement and crude practices that include drugging, diets based on raw 4D meat, and of course, live lure training. Live lure training is also called jacking, and this occurs, and it's a standard. Young dogs are baited and allowed to tear apart small animals. The idea is to blood them to enhance their racing instinct. That cruelty aside, by any standard, dog racing is cruel and inhumane and causes suffering to the animals involved. Just like dog fighting, it has no place in modern society. It should no longer be accepted or tolerated under the law. In Connecticut, although live racing ended in 2005, under current statute, it is perfectly legal to own and operate a dog track. By contrast, this activity is illegal in 42 other states, including all of the surrounding New England states. So in conclusion, I hope that you will support Senate Bill 132. It will ensure that dog racing cruelty never finds a home in Connecticut again. It closes a dangerous loophole now and allows you to join the 42 other states that have already rejected this disreputable and outdated form of gambling. I have submitted written testimony, which I hope that you will read. And if you have any questions, I'd be so glad to take them.
Questions from the committee? Anyone online, MJ?
No questions online, Mr. Chairman.
Thank you, Christine, for your continued advocacy. We're very, very sorry you lost her, but we enjoyed having her last year, and I'm sure there'll be another adoptee in your future. And we'll look forward to this getting out of the Senate this time and getting down to the House. So
thank you, Mr. Co-Chair.
Gets very upset there were no dogs in the committee room.
yes, I know
Looked at the
he
agenda.
he does. I got text from also some of your House colleagues as well. They were looking forward to coming, but we decided to keep it a little short. So thank you, Christine. Appreciate you testifying.
Thank you so much.
MJ, who would you like next?
Up next online, Mr. Chairman, we have Michael Gorgon.
Thank you, Mr. Gorgon.
Hi, can you hear me?
We can. Perfect. Loud and clear.
Hi, my name's Mike Gorgon. I am the owner and brewer for Mercine Ale Company in Old Saybrook. I was going to speak mostly on the 5 miles, but there was definitely some clarification, which I guess we just need to get the language right. So that was a good chunk of what I was going to say. But other than that, the only other part I was going to bring up was I am not with a distributor, but I would like to sign with one, but I have had hesitations since starting in 2022 due to the fact that if I sign with a distributor, I won't be able to, my small mom and pop places won't be able to hit the minimums, and I won't be able to sell the one-off kegs that I make in my tap room right now. If I sign with a big brewery in the state and then I sell to the distributor. So I think the I have lost track here. Sorry. Yeah, sorry, I lost track where I was going with this.
Take your time. Go ahead.
Currently the laws that are if you sign, you're stuck with the distributor. You're not able to co-sell with them. I think we need to be able to get that adjusted at some point. But yeah, I'm a very small brewery in Old Saybrook, but trying to grow in the state of Connecticut. I do think Connecticut has some of the best beer in the country, and I think we need to change before we end up closing more breweries because they can't grow. I thank you guys for your time. Like I said, I was going to speak mostly on the 5 mile thing. I thought the way it was written was if that went through, I wouldn't be able to sell a keg past 5 miles, and that would kill me. I would probably close my doors after 6 months if I couldn't sell to restaurants beyond 5 miles.
Yeah.
Thank you for your time.
We understand that, and like I said, that's certainly, that's not how we read it, and was not the intent. And if you want to self-distribute, you can still self-distribute.
Yeah, there was a lot of talk between text messages and friends in the industry the last week or so that were nervous about this. So we definitely got to get the wording clarified.
I assume you're in favor of section 3. I don't whether you'll would choose to avail yourself of that or not. If you wanted to under a Connecticut cafe permit, if you wanted to avail yourself of that permit.
So yeah, so I'm a big believer of supporting local. I know the craft permit talks about how you have to buy Connecticut made spirits, which I probably will never buy outside of Connecticut, but I understand how it's written and it is not, it needs to be changed. The one thing was the way it's written, I have to buy directly from the manufacturer, but if there's a manufacturer has a distributor license, I would have to buy from the distributor, but with the craft permit, I can't buy from the distributor. Did I say that in the right way?
Well, I think you should check with whoever you're talking to on that. No, the law lets you purchase the Connecticut craft wines, ciders, if this passes, other beers, through direct or through distributors. Again, depending on whether that manufacturers availed themselves of either the self-distribution option under a certain amount or distributors. So just want to make sure our bill is clear, and I think it is, and the existing law is. So other questions from committee members? MJ, anybody online?
No questions online, Mr. Chairman.
Great. Thank you, MJ. Thank you very much, Mike. Appreciate it.
Thank you for your time.
Who would you like next, MJ?
We have Rachel joining the room now.
All right. Rachel Diamond from the Connecticut Brewers Guild.
Can you see me?
And hear you.
Yes, that's very exciting. Good afternoon, esteemed and honorable Chairman Moroni D'Agostino, Vice Chairs Fanfara and Brown, and the incomparable ranking members Ritigliano and Ciccarella, and all the members of the General Law Committee. Thank you so much for having me here. My name is Rachel Diamond, and I am the Executive Director of the Connecticut Brewers Guild, and I have the proud and distinct privilege to represent over 120 local craft breweries in our great state, including my own, Broken Symmetry in Bethel, Connecticut. We are, in fact, a very rare and noble breed of manufacturers that put an emphasis on enjoying life, and we truly care about the art we produce. We root our businesses in supporting our community, and we take the time in a world of digital detachment to provide a much-needed space to create real connections. I'm hereby today to speak about proposed Bill 5149. So you have included some new amendments, and I know we had approached this committee with our deep concerns about the economic state of our industry, and perhaps the committee believes that maybe this proposal that you put forward would make a positive impact. But I am very concerned about the changes in Section 1 and Section 3, that they might not have the desired impact that you're thinking about. Our already standing beer manufacturer permit that you want to change, outlined in 3016, already grants the brewers the ability to sell and distribute beer across Connecticut. It is adding some confusing language proposed in 5149, Section 1, that, depending on who was looking at it, and I know that we've discussed it already in this hearing, but it could potentially limit rights of keg sales. I know that's not what you want to do. I believe your intent was to carve out a path for the Connecticut brewers to distribute alongside wholesalers within a limited radius. And to do this, you actually can't amend 3016. You have to amend 3017, which is the wholesaler law. And if you want to create a carve out like this, it would have to be not providing preferential treatment to Connecticut breweries and discriminating against out-of-state breweries, because we all know that's against the dormant clause of the Constitution. We believe in making a concession for the smallest breweries, those producing 60,000 barrels or less per year, and to have dual assignment to sell their beers alongside wholesalers. This will stem the bleeding in our industry, and we are not looking to redact or cancel our existing contracts with our wholesalers, simply sell alongside in hopes of controlling our own destiny. The latest market analysis done by Bump Williams Consulting this month, a nationally renowned beer market analysis consulting firm, says that the craft beer is just 6 to 12% of the beer market sales across America, with the top 83 of those sales coming from the top 15 producers like Sam Adams, Sierra Nevada, New Belgium. And that leaves 9,540 American small craft breweries that split the last 2% of that beer market share. We only have 120 breweries here in Connecticut. And even our largest producer, Two Roads Brewing, is just a tiny 3% of the wholesaler's revenue. 3%. So if Two Roads were to close tomorrow, their wholesaler wouldn't even notice. But you know who would notice? The employees, the craft beer lovers who come out for every community function, the thousands of vendors who support the brand, and the myriad of charities that brewery supports. By allowing the smallest craft breweries to service mom and pop accounts that the wholesalers do not deliver to because they do not meet minimums or they need financial flexibility with last-minute drop-offs, we keep our neighboring small businesses, our neighboring restaurants and package stores afloat, and allow the wholesalers to continue their sales as they normally would without infringing on their business. The wholesalers will tell you that this is the camel's nose under the tent. That's something that they've said over and over again, and it will bring down all of franchise law, but that is simply not true. There's a real need for high quality wholesalers, and us brewers want to be partners in creating long-lasting brands by helping build our businesses. Wine, cider, spirits, they already do this, and beer should be no different. I implore you to refrain from amending the manufacturing permit and enact wholesale reform to Connecticut's wholesale laws, which have been in place since 1972 when there were only 9 big breweries across America. In regards to Section 3, is our position that the Connecticut Craft Cafe permit is definitely against the dormant clause of the United States Constitution. It provides preferential treatment to Connecticut manufacturers, and it discriminates against out-of-state manufacturers. Not only that, but there's only 55 breweries that currently hold this permit, making it almost defunct. So in a meeting that I had with the chairman of this committee, it was suggested that the brewers be able to obtain and hold cafe bar permits. And this would allow the breweries the ability to get lower cost and more readily available products to keep their customers happy without having to change their business model to becoming a restaurant or hold a liquor permit. We support local as often as we can because we would want to support that support in return. But the lack of options in permitting for small craft breweries here in Connecticut is forcing our breweries to become restaurants. And you have to remember that these are friends and family that start home brewing in their garages, not restaurateurs. And I fail to see how adding more burden to the already burdened restaurant industry can possibly be helping with, their own battles in this economy. Again, we're talking about 54 breweries, not thousands, not even 100. You have the ability to make things right, not put these small businesses in financial jeopardy. So the brewers cannot stand by the Craft Cafe permit in 3022. We require a new path forward, and hopefully you'll allow us to.
We're past the 3 minutes there, Rachel.
Okay. Well, I've got one sentence left. Do you want to hear it? No.
I think I get the point.
Okay. Thank you.
I mean, if you don't mind some advice.
Yeah.
I mean,
I'll take it.
I'm a little perplexed that after this committee really bent over backwards to put something out there that I appreciate doesn't go as far as the brewers wanted, that you would all show up today and oppose these sections, and frankly, on just completely wrong grounds. I mean, you couldn't be more wrong about the Dormers Commerce Clause issues, because if you're right on that, then the entire scheme is unconstitutional and has been. And if what you guys want to do is go ahead and challenge it, go ahead and challenge it. But you know, we didn't give you everything you wanted, but the leadership of this committee put something out that we thought would at least go a little bit toward what you wanted. And instead, I've got a bunch of testimony from your members opposing the very things we put out that we thought helped. So, I mean, that's the message I'm taking away so far today. Just for anybody else who's planning on testifying on behalf of the brewers today, is that you don't want any help. Thanks, but no thanks.
No,
So,
we do. I'm sorry, Chairman. Of course we want help.
well,
The
let me ask you. I mean, Section 1, I think I've made clear what it does.
Right.
And frankly, we think we're correct on the language.
So-
if you guys have an
So-
opinion from legal counsel, we're happy to take it under advisement. But we kind of know what we're doing when we do this stuff,
So
and
we
we think
already-
we're right on this. So,
We
let me
have-
ask you directly: is there an objection that your members have to
There-
what we proposed as I've explained it?
We believe that because you have given it in our permitting structure, which already grants us the right to self-distribute our products across Connecticut, that as soon as we sign a wholesaler license or a wholesaler agreement, that gets null and voided. So we are concerned that by adding something else to the permit, it doesn't actually trump or help when you sign a wholesaler permit. So we can't dual assign. It won't make a difference once you sign a
Yeah.
wholesale permit.
We'll look at this, but that's not how we read it, nor how one interprets statutes as a whole. And again, if you guys have an actual legal opinion, rather than somebody just sort of texting what they think it means, send it to us. But we think we understand how 3016 and 3017 work together, and when we put in specific language, how it can trump the general. But again, I hear you on that concern.
Mm.
That issue aside, assuming we assuaged any concerns in that regard,
Yes.
does the Connecticut Brewers Guild oppose what we are proposing with respect to the 5 mile rule, assuming it does not undermine self-distribution otherwise?
Assuming that it does not undermine self-distribution, and assuming that it goes a little, it doesn't go a long way. It is not much of a thrown bone, in our opinion, but it is something if you are willing to put it into the wholesale. If you're saying that 3016 does trump 3017, then we don't even need it. We are already granted the permission to sell all over Connecticut. And if you want to make that clarification, that
No,
36
again, what we're talking about here
Mm.
is if you have a contract with a distributor
Mhm.
and you have to use that distributor,
Mhm.
this would allow you to still self-distribute within 5 miles to an existing permittee.
I understand that is the intent, but from
Okay,
all
all right. So language aside,
Mhm.
does the Connecticut Brewers Guild support or oppose that concept, assuming we get the language correct, which I think we already have. But that aside,
I
it's a
think
yes
if-
or no question.
I think if you can get the language correct and that it will allow us to distribute anywhere in a 5 mile radius if we have a wholesaler contract, it is in fact a concession from what we are doing now. It is not what we asked for, but it is something.
Fair enough. Okay. All right. Let's move on to section 3. I appreciate that you want a more expansive cafe permit rights and bar rights. That's not what's before us today, but you've made your argument for something more expansive. That's fine. Does the Connecticut Brewers Guild support or oppose the language we've included and that we have before us?
The language that you have included does not readily change anything for us.
Okay. Fair enough. questions from committee members? Representative Yacarino.
I'll be very brief, Mr. Chair. I listened to Ms. Diamond, and since I've been here, I think 10 or 12 years ago, we only had a handful of craft breweries, and that's a great thing. We supported it. But what I'm hearing today is nothing is going to be enough. And I'll go back to the distributors, is that they have a lot at stake, and so do you. And I appreciate that. I have a small business. I work my butt off, and I have to compete with some of the largest companies in the world, actually. But it's through competition, and you have the ability now to craft brew. You could have food. You could have people come to your venue. You could have music, and it's a great thing. We've expanded it, and I think it's wonderful. But you have 120 craft brewers in Connecticut now. What I think 10 years ago, there's probably 10.
Mhm.
You feel, Ms. Diamond, that 120 is eating away at the profits of the industry? Because I think it's a separate industry than the distributors, who, like I said earlier, both you employ a lot of people, but I think there's enough for both. So are you saying that the 120 is too much for your industry, or you just want more to make it feasible for your bottom line?
We're not commenting on how many we have, because obviously the economy in the past few years has allowed this growth of craft brewers. And I think everybody has used them as community centers for their towns. You know, everybody's kind of congregated there, which we love. I do think if you're talking about actually competing, this is something that we're asking for. We are asking to compete and not be held back by somebody telling us, no, this is how you have to sell, or this is how much we're going to sell. For example, if my wholesaler orders X number of cases and they don't sell those number of cases, they just throw it out and charge us back for it. We don't have the opportunity to go out and sell our own product beyond that. It is wasteful. It is something that we are witnessing. The other day, our representative in our area for our wholesaler came in to our establishment, and I will tell you that my brewery earned between $16,000 and $17,000. That's it, in outside beer sales this year. But that representative told me that her route pulled in $2.5 million, and there's 20 of those routes across state for that one company. Now imagine, you know, the 5 or 6 wholesalers. This is something that they're able to do. And I am not a priority. These little guys are not a priority.
I appreciate that, but I don't, it's all about competition. And I think the cases you said are returned to you, you should be innovative and sell those in your places.
They are not returned to us. They are disposed of.
Well, I'm not sure about that, but I think that you should be able to work with the industry, and you have a lot of opportunity, and I would hope you would take advantage of it. I think there's a lot of opportunity out there through legislation and through fair competition. And I think the distributors do a very good job overall. I really do. And I think your industry is good, but it's a niche market, and you have the community base, but you have to remember it's a business. Both are businesses. You have to keep that in mind. Thank you, Mr. Chair.
Thank you, Representative. Other questions? MJ, anyone online?
No questions online, Mr.
Committee
Chairman.
members here? Thank you, Rachel. Appreciate it.
Sorry.
I'm sorry. Go ahead. Hold on.
He put it down, but Rep. Ali Brennan did
Yes.
everything.
Yep,
Yes,
hang on.
sorry, I do.
Rachel, you still there?
Oh yeah,
Hold on. Okay, yep, good. Okay, go ahead.
Thank you, Mr. Chairman. Yes. Hey, Rachel. Thanks for testifying today. I know you brought up the Connecticut Craft Cafe permit. I just was trying to see if you could expand a bit more on, do you know how many breweries have that permit right now? And basically, how would access to the cafe bar permit, change the way you guys do business? Just curious to hear more about that.
Sure. So the Connecticut Craft Cafe permit allows us to buy only Connecticut-made alcohols, specifically ones that we do not manufacture. So if I wanted to buy an RTD or a wine or a spirit, that would have to be Connecticut made if I held that permit. There are approximately 54 of them currently right now. There was a lot more last year, but that significantly diminished because of the permit. They all changed into restaurants. They got the restaurant liquor permit. What it allows you to do is if you have a group of 4 people coming in and one of them really loves beer or 2 of them really love beer, but one of them wants a wine, you can give them something, right? And that's great the craft cafe permit still allows you to do that. However, as you know, Connecticut made wines, they're not the things that people want all the time. And they're not easily accessible either. We're talking about only so many barrels are made every year. So if they're not consistently available, it's very hard for people to get them. The same thing if people want, you know, a cocktail. We at our place craft batch cocktails into kegs and you know, pull them out of the beer launcher with the kegs. And yeah, and that's how we do it there. But again, we have a restaurant liquor license. If you were a Connecticut craft cafe license, that would cost you an arm and a leg. You'd be charging $24, $25 for this thing. And obviously the person who wants those items might say, all right, well, I don't want to go to the brewery tonight. I'd rather just go somewhere else. And we're talking about if we can have the ability to bring those people in, that 4 top in, make everybody happy for a really good price, and then send them to the great, awesome restaurant down the road, we would be supporting the restaurants and not taking away from them by adding more restaurants. Does that answer the question?
Yes, thank you. Yeah, and just one more thing. I mean, listening to your testimony, you know, I just wanted to give you the opportunity just to expand a bit more on if you can give me an example, like 1 or 2 examples of just, you know, things you've observed firsthand, you know, from the wholesalers that, you know, I know you talk to them directly and, you know, you've tried to work a good relationship, but, you know, what are some things just to help the committee understand better too, you know, that you've observed, even though that you, I guess, can describe as predatory, but, you know, not that I would, but I'm just curious to see, you know, if you could just expand, give us an example, 1 or 2 that has been troublesome.
Sure. So if you say that you're unhappy with your wholesaler, they can withhold selling your product. That is a thing that has happened multiple times. You notice that there's not a ton of testimony today because people are very afraid of what will happen if they come forward and they say something against the wholesalers, because this is their majority that they put out in the world. Places like Two Roads, Beard, Thimble Island, these are breweries that get the most amount of their revenue from these out of house sales. And it's very scary to put themselves on the line like this, when potentially, you know, the wholesalers could just stop selling their product. And we're in lifetime contracts. We can't get out of it until we can prove negligence and go through a number of hoop jumping to be able to get out of it. And once you hand over a brand, that's the end of it. It's like, that's the only way that they can sell. I told this example in the committee meeting before, but right across the road, we have a Italian restaurant and they were out of beer completely. But our wholesaler said, you got to sign all these paperwork and you need a $350 minimum, and we only drop off on Thursdays. Well, that's something that's very difficult for a small business to do. When they're out of beer, if they just need 1 log and it costs them $90, they can't spend the $350. They can't wait a week to do that. And that means that it's going to get filled by a different product from a different wholesaler, and my beer is off the line. It is about customer service, but there's always a middleman, and that middleman is taking the majority profits of our hard work. And we're asking not to take away the contracts. We are asking to sell side by side, so those places feel like they're taken care of. So the next time the wholesaler wants to sell to them and say, hey, you got to wait till Thursday, they go, okay, that makes sense. It's about consistency, about keeping customers happy, and it's not about trying to take away from the wholesalers. We wouldn't be able to exist without the wholesalers. So we just need help. That's all.
Thank you. I mean, I appreciate those comments. I get the frustrations, and I, you know, appreciate the chairman and the committee wanting to help. I know sometimes it's not enough, but I do think it's an important dialogue, and appreciate you taking the time today.
Absolutely.
Thank you, Mr. Chairman.
Thank you, representatives. Anyone else? Thank you, MJ. Thank you, Rachel. Appreciate it.
No problem. Thank you, Chairman.
MJ, who would you like next?
Next up online, I am admitting Aaron Simoncini.
Thank you. Let me know what he's in.
He is in.
Oh. Mr.
Hello.
Simoncini?
Yes, how are you today?
Oh, we can see and hear you. Great. Thank you. Please go
Beautiful.
ahead.
My name is Mr. Aaron Simoncini. I am the Vice President of the Connecticut Brewers Guild and the owner of the Beard Brewing Company, an independent craft brewery located in southeastern Connecticut. I would like to thank the esteemed members of the General Law Committee for their time today and allowing me to provide comment on Bill 5149. The Bill 5149 presents two adjustments that pertain to the craft brewing industry here in Connecticut. And in an attempt to not beat a dead horse and absorb what we've already heard, I think that Section 1 at face value, there is definitely a little bit of confusion, and I think it stems from the use of retail versus wholesale. We obviously can self-distribute wholesale. Via wholesale, we're allowed to sell to retail permittees. In our industry, it's a little muddied because we get to operate tap rooms where we strictly retail. We're also allowed to distribute or wholesale. So I think the way that it reads now might need a little bit of fine tuning because it's pointing to retail of these kegs within a 5-mile radius. And I think that would fix that. So if we're able to clarify that section of the bill and 100% confirm that it's correct, I can fully support that and appreciate the consideration for our industry, for our burgeoning industry at 130 some odd brewers. The real issue for our membership, though, isn't really the small volume of kegs that could be sold within a 5-mile radius. It's the fact that our much larger wholesale business can be held hostage by a distributor relationship that once might have made sense and for one reason or another maybe doesn't any longer. Rather than depend on the interpretation of just and sufficient that the chairman kind of evoked earlier, just and sufficient cause, a path to dual assignment for suppliers would allow small in-state manufacturers the ability to roll up their sleeves and fully represent themselves in a struggling marketplace, once again, kind of providing the opportunity to compete and hopefully offer the best quality service to the final retailers or consumers. Strong beer wholesalers are an asset to the beer manufacturers here in Connecticut. There's no question that they're our partners. I believe at this point I operate the largest self-distributed brewery servicing every county except for Fairfield and Litchfield, for which we do have a wholesale partner, and then we distribute outside the state via wholesalers as well. So I'm intimately familiar with how you need to work together to grow the brand. However, a continuing trend of consolidation, SKU proliferation, and restricted access to market leads to kind of small brands losing their mind share at these larger wholesale houses and an anti-competitive beer marketplace for the final consumers. A move to dual assignment would serve to rectify these issues, providing for competition among wholesale operations within geographic territory. I guess finally here, Section 3 looks to augment the Connecticut Craft Cafe permit. And I can understand what it's going for there. It would be a little more restrictive in the fact that it's naming the fact that we can only retail one collaboration beer at a time. And in spirit, it made sense at the time when the manufacturer for beer and brew pub permit was rolled into or consolidated with everything else. In hindsight, that kind of consolidation of permits for our industry resulted in manufacturers now having to hold 2 permits. Myself, in my instance, a manufacturer permit for beer and a craft cafe permit. And so it kind of just diminished the operational abilities of our organizations. I would like to urge general law to revisit the manufacturer for beer and brew pub language when reviewing this in the future. I think that could be very helpful and perhaps cut down on the number of permits that we all have to pay for and renew every year. Thank you all for your time and consideration for these matters today, and I'm happy to answer any questions that you may have.
So again, with respect to Section 3, again, the intent there is currently under the Connecticut Cafe permit, if a 3016 manufacturer avails themselves of that permit, they could sell Connecticut wine, Connecticut cider, but they could only sell the beer that's manufactured on premises, and that collaboration.
Or a collaboration.
Yeah, which was a little bit muddy, I admit, from last year. Do you think that there are brewers who have the Connecticut Cafe license who would avail themselves of the ability to sell other Connecticut craft brews if under that license if we pass this language?
Yeah, I think more is better. And with that said, I think we could support that.
Great. Okay. Questions from committee members? Representative Vitiliano.
Good afternoon. Just on background, do you still self-distribute your brews or do you go through a distributor?
That is correct, sir. I manage both. In state, we have to assign distribution rights by territory, geographic territory. And so every territory or county, leaving out Fairfield and Litchfield County because I'm in southeastern Connecticut, it's just a bit too far for us to reach out and touch in a meaningful way. So we partnered with a fantastic beer wholesaler group, and they help us do business in those two counties. So it's a bit of a blend.
So you self-distribute in and around your location, but you signed with a wholesaler in another part of the state.
That is correct. Yes. And so in regards to this bill, it's not really going to make a difference from my personal perspective because we maintain New London County ourselves, which is where our two locations are located. You know, I could see how if you were signed with a wholesaler for New London, if I was signed with a wholesaler from New London, how that could make a difference. I'll be, you know, following the pandemic, the split of package versus draft beer has really fallen off. You're seeing restaurants and retail establishments pull out their draft lines in favor of offering, you know, packaged beer for pour into a glass.
So when you send your beer to the wholesalers that distribute for you down in Fairfield County, say, what happens if the product ages or they don't sell the product?
So if the product ages, generally, you know, and I commend DCP for clarifying this because it was a big problem throughout the pandemic when you know people were kind of buying on consignment, I guess is what they call it, and buying more than they knew they could ever sell and then returning it became a big issue. And DCP has clarified that you know, enforcement recently. So that's fantastic. When it does in fact age out, so generally we're looking at a 90-day shelf life is generally average for craft brewed product. When it does age out, our wholesalers will credit that back to the establishment, and it depends on your individual contract. I love being able to contract with the wholesalers and not, you know, and be able to make those terms, but it's a 50-50 split in my case. As far as the credit that goes back.
Return expired beer to you, you get charged 50% of whatever the money they gave you to purchase the beer in the first place?
That is correct.
Do you have the ability when you make a contract with your wholesaler to say, listen, say you sign with a wholesaler in your direct area. Could you currently right now look at that wholesaler and say, you're gonna now have my brand A, and now you're the distributor for brand A, but I'm gonna keep these 4 establishments that I'm going to distribute to. Do you have that ability, or is it all or nothing?
As far as I know, no. That would be a very granular kind of conversation and something that I don't know that would end up working. It might create more confusion in the long run, to be honest. You know, it's interesting enough when you have to assign general territories. I mean, I've certainly, mistakes happen, but I've certainly had where my Fairfield, Litchfield County assigned wholesaler may have sold into New Haven County. and so that becomes an issue, but obviously we have to clarify that and have the conversation. And it's an ongoing partnership. Again, we're not here to vilify our wholesale partners. It's just, the just and sufficient cause, it's really hard to define that, right? There's what is just and sufficient cause? Is it, you know, the weather is this way today, or are they selling into my territory and that's just unacceptable? So it's really hard to crystallize some of these things, or prove that they even go on. You know, oftentimes I find myself wanting to carry a tape recorder so that I can grab some of these requests or conversations, whether it comes from, you know, retail or wholesale or whatever it may be.
I guess my question was, and then maybe I didn't state it well enough. You could decide now that you're going to sign on with a wholesaler distributor in where your brewery is located, where you currently self-distribute.
Yes.
Can you or can you not just look at them and say, you know, I'm going to give you my beer, I'm going to give you my label, but I'm going to keep the 5 miles around my brewery? We need to fix that for you in statute?
We assign, and I believe statute prescribes this, that you have to assign based on geographic territory, which is counties within Connecticut.
but do you have the ability to negotiate on your own that you're keeping a 5-mile radius around your brewery?
As far as I know, no. And you know, I'd have to review once again, but as far as I know, when you prescribe a county or sign off a county for a wholesaler, they service the entire county, and you are no longer allowed to say within 5 miles.
If you were able to do that, say you're going to sign with a distributor, but you're going to look at that distributor and say, I'm keeping the 10 miles. I want to do 10 miles from my brewery. Would you be more apt to sign with a wholesaler in your area? Or is that something that maybe would be an incentive for you to wholesale, or doesn't it matter?
I think it would push it further in that direction. It would make the terms more favorable. It's something that I certainly ran into in Fairfield and Litchfield County. We've had one major retailer group that was kind of unhappy with our wholesaler, and you know, there's a pricing difference. We can't necessarily get into the nitty-gritty of that, but our wholesale partners offered us to service that retail chain in that county. Now, again, I don't know that that's kosher per the statutes.
Yeah. Okay. I won't ask any more questions. We could definitely have that conversation. I personally think it's kosher because, listen, you can negotiate. If you have the ability, I believe, to negotiate whatever you want, whatever your deal looks like, and nobody's complaining, then I think the brewers probably have more flexibility than they think they do. So I was just trying to make that clear for you.
I thank you. I thank you for that. And that's certainly something I'm going to look into. Again, appreciate that piece of information.
I think the issue would be, from just to sort of continue the debate, would be because of the way the statute's drafted, the wholesaler has more leverage to be able to fall back and say no under the statute.
True.
I'm backed by. Whereas if we just said, just negotiate.
Do they get to say no before they sign the contract? So yeah, you're probably right. Once they sign the contract,
If they want to say, but I think you're right. If the two parties, I mean, it's a perfect example. If the two parties agree, nobody's going to complain under this. No one's going to avail themselves of under the statute. Now, that's while the relationship's good, things go bad. You know, you see where that ends up going. But it's a.
I would be curious too, just to not change the subject because it's interesting, is how much of the beer actually goes back to the brewers. I would find that would be a shock to my business if I had all that money in my bank account and all of a sudden I had to give half of it back. I would think would be.
Aaron, I don't know if the Connecticut Brewers Guild, can you guys poll your members and get us some data on that?
Absolutely. Yeah, that shouldn't be an issue. You know, and again, it's going to come down to size and scale, distribution pattern. So, for example, we don't take a ton back as a self-distributing brewery. However, you know, the further from home you go, the less brand recognition and maybe the less feet on the street you have as a brand in that wholesaler's territory. You're going to see more coming out of that. So I think we can probably get you a good cross section of the larger and smaller distributed breweries here in Connecticut.
Thank you.
Great. Thank you. Thank you very, very much, Representative Chigliano. Other questions? Anyone online, MJ?
No questions online, Mr. Chairman.
Great. Okay. Thank you, Aaron.
Thank you all. Appreciate the time.
MJ, who would you like next?
Up next online, I have Ed Schreiner. I'm adding him right now.
Mr. Farrar, are you good? If it's up to you. If you would like to testify, I can put you back in. Great. I'll get you right after this guy then. Great. Terrific.
Ed is in the meeting.
Mr. Schreiner? Can you hear us? Mr. Schreiner?
Yeah, I'm here. Can you hear me?
Great. Yep, we can.
Sorry, technical difficulties on my end. I apologize.
No worries.
Chairman D'Agostino and members of the committee, my name is Ed Schreiner. I'm the owner and pharmacist operator of Stoll's Pharmacy in Waterbury here since 1988. I'm also the immediate past chairman of the board of directors for Northeast Pharmacy Service Corporation, which is a buying group that provides business development services to a large number of participating pharmacies throughout New England, including over 100 here in Connecticut. So I appreciate the opportunity today to testify in support of Senate Bill 133, an act concerning regulation of prescription drugs and related professions. I'll apologize for wearing the headset today. Right behind me is my pharmacy staff, and for HIPAA purposes, I want to use the headset today. So I hope that's not a distraction for anyone. But specifically, I wanted to talk about Section 4 of Bill number 133, which talks about compliance drug packaging. So compliance drug packaging allows pharmacists to help patients who are on multiple medications that are often prescribed by multiple doctors for multiple medical conditions. And we promote appropriate drug use by organizing these meds in multi-drug blister packs by time of day. So we'll give them a morning pack that has all their morning meds. We'll give them an evening pack that has all those meds. We'll have some bedtime pack, and it's customized to the patient. And this started being used more primarily in long-term care with our assisted living as residential group homes. But when the COVID-19 pandemic came, there was an expanded need for these in the home setting as patients and families opted to avoid those congregate living facilities and keep people home. And we refer to that as the medical at home or the long-term care at home patient. So these are great ways to help people in their homes who may not have any medical training or medication past training like the institutional facilities have. We help them manage their meds, and these packs are a really excellent way to do that. The issue is the largest barrier is currently we can't change those packs, take them back and repack them if a medication changes. And I think that's unsafe for patients. And I just want to give you a personal example. So I have a patient in his home. He takes 11 meds every morning. And one of them is amlodipine 5 milligram. And it's a little round white tablet, which a lot of pills are. So his doctor, 2 weeks into his monthly cycle, decided he had an appointment and needed to increase that to a 10 milligram tablet. So we couldn't repack the tray, but we sent the 10 milligram pills in a bottle. And I called him up and said, okay, you have to take the little round white pill that's in your tray out, and don't take that, and take the pill I sent you in a bottle. The problem with that was his morning tray had 5 little round white pills. And the next thing we hear, he was in the hospital because of low blood pressure. So what happened there is he took a little round white pill out, but it wasn't the right little round white pill. And so he was taking both the 5 milligram blood pressure pill that was in the tray plus a new one to get 10 milligrams. So he was overdosing on that. Plus he was missing whichever white pill he didn't take. So he's missing a med that he should have been taking. And this all could have been avoided if we could just repack. And so that's what Section 4 of this bill is really addressing. And it makes it much safer for the patients in their home to allow us to do that. That situation never would have happened. That patient would have avoided a trip to the ER if we had been able to do that. And that's probably the most important part of the part of the bill. I had spoken personally with Drug Control Director Marriott about the ins and outs of how a pharmacy does this and can do this safely without, one of the concerns was, well, what happens with the medication that gets removed from the tray? Because we can't put it back in stock and dispense it to another patient, and that's appropriate. So, I have in my pharmacy methods that I thought, and I shared with Director Marriott that, we can systematize this so that that's not a concern and it can be regulated. And that's incorporated into the wording of this legislation. I will say that I think there's one typo in one section. It talks about you can't put controlled substances into this packaging. But later it says you have to keep a log of controlled packaging, controlled substances that are removed. I think that wording meant to say all drugs that are taken out of the package should be tracked. And so there's a paper trail. But other than that, I think the wording in the law is very good. So, you know, SB 133 closes this gap for the patients by allowing us to repack. I would comment about one other thing. The clerk position, I had heard earlier it described as being a cutout for a pharmacy position, and really, I don't think it is as an owner of the pharmacy. I think it's an add-in, and it's my understanding that DCP's desire is to oversee all aspects of the pharmacy. So our cash register clerks, we're taking a sealed bag and processing the cash transaction through the cash register, aren't necessarily trained professionals. They're trained on the cash register, but what they are trained is, do you need to speak to the pharmacist about your medication? And that offered a consult. So the clerk position, in my mind, is giving DCP a way to oversee those non-professional activities that still occur in a pharmacy every day. And I don't disagree with that. I understand that. I would ask though, you know, every time there's a registration, and if you look through that bill, there's a lot of fees there for a lot of other registrations. I would hope we don't have to pay a fee for every single cash register clerk or delivery driver who's handing meds to a patient. You know, that would be really another fee. Is just another burden on businesses and these people are not trained healthcare professionals. So there is no license for them. They're just, you know, I would hope there would not be a fee for that. So that's all I have. If you had any questions, I would be more than happy to answer for you.
Thank you. Questions from committee members? Anyone online, MJ?
No questions online, Mr. Chairman.
Thank you. Thank you for taking the time today out of the office. Appreciate that.
Okay, thank you very much. Appreciate it.
Great. Mr. Cafaro, sorry, I skipped over you.
Thank you. Good afternoon, honorable members of the General Law Committee. For the record, my name is Larry Cafaro. I'm the Executive Director and General Counsel of Wine and Spirit Wholesalers. I am not here on behalf of the beer wholesalers. They have wonderful representatives that could speak for themselves. I'm here simply to respectfully remind the committee about the three-tier system, and in particular, I do that in light of Raised Bill 5149. The bill has 3 sections to it, and with due respect, I believe in each section, it expands the ability of certain players to cross over into another tier. By way of background, real quick, you probably all know this, with the end of Prohibition, all 50 states adopted a 3-tier system where they kept separate the supplier, manufacturer, the wholesaler, distributor, and the retailer, both package store and restaurants. There was a good reason for that because a lot of bad stuff happened before Prohibition when one tier was allowed to self-distribute, to open a restaurant, et cetera, et cetera. Over the years, especially in deference to our small craft breweries, distilleries, and wineries, we have made exceptions to that rule. This particular bill purports to expand those exceptions. And I want to caution the committee that the further we erode the 3-tier system, the worse off we are here in Connecticut for our very successful, at least for 90 years, alcohol beverage system. What do I mean by that? In the first section, although I will say that Chairman DiAugustino explained the confusion, and I'd be lying if I said Section 1 is just this terrible violation of the 3-tier system. Will allowing small breweries to distribute kegs within 5 miles to restaurants in certain circumstances turn the world upside down? Absolutely not. But what it does do is expand the rights of a manufacturer to be a distributor. In the second section, we allow a package store to start charging for tastings to make, frankly, a profit center out of it. And unless I'm mistaken, there's nothing in the bill that would prohibit a package store from setting up permanent tasting rooms, if you will, where they would charge for groups to come in and taste their products. So they are now morphing from a off-premises package store into what could be an on-premises tavern or restaurant. Again, the blurring of the lines. In the last section, the bill expands the rights of Connecticut craft cafes. It expands what they could sell. So the question always is, what are you? Are you a manufacturer of these beers? Are you a restaurant? Are you a package store? You heard from some of the people in the craft brewery, they want even more. They want to be able for you to come in and not only purchase their product, but any other product, not necessarily made in Connecticut, but anywhere else. With due respect to some of the testimony I heard with regard to that, if I went to an Italian restaurant, I wouldn't expect to get spare ribs there. I went to an Italian restaurant, I'm not expecting Chinese cuisine. When you go to a brewery, you expect to have that craft product. You don't expect to have a nationally sold Chardonnay. So I guess what my cautionary tale said with due respect is, let's make sure we preserve the three-tier system and we have people for the most part stay in their lane. The more we erode this three-tier system, the worse off we would be. That's the sole purpose of my testimony today. I'd be glad to take any questions. Thank you for listening.
Thank you, Mr. Cafaro. So on section 2, is there language that would the general concern aside, is there language that would ameliorate your concern about the tasting rooms and, a package store setting up a bar, which obviously is not our intent?
I would realize that, Mr. Chairman. And right now, I mean, you have a system that has allowed people to come in and taste at no charge a product that the package store might be selling. I understand you often hear about Pappy Van Winkle, that this is an incredibly expensive alcohol spirit, that if somebody wanted to taste that, they better pay for it because it's really pretty expensive stuff. If that's why we're doing this, then maybe they shouldn't have tastings of Pappy Van Winkle. By the way, last I checked, there's no shortage of demand for it. So it's not like they have to entice people to buy it by having a tasting for it. So the system we have is pretty good. It allows retailers to offer samples to their customers of maybe a new product that they're carrying. That's good. That makes sense. But now to start charging for it, if you make it a profit center, then the kind of maybe worst case scenario that I described with dedicated tasting rooms that invite, private parties to come in and, and then maybe they could bring their own food in or whatever. And now you're morphing an off-premises retailer into something else. And again, the lines are blurring.
I
and
guess what I'm saying, obviously we're not interested in
I
doing
know you're
that.
not.
So,
But can you understand how that might happen with being able to charge for a sample?
yeah, I also believe we could probably come up with language that would prevent that from happening, though. And I'm saying
And you
if we,
probably could,
yeah.
Mr. Chair, but I guess my question would be, so what's the point?
Well,
Why
I
would
guess
we
that's
have-
my question to you. I mean, you do this, the incentive to do this from a package store's perspective isn't to make a profit from a taste of some wine. It's to sell the bottle of wine or a case of wine.
Right.
Which at the end of the day, not only benefits the package store, but your clients.
Right. So why do you charge for it?
So why are you opposed to it?
The charging for it?
Why do you care if the end result is more sales?
Well, is it right now they could offer a sample of that and hopefully they buy the wine. That's a sale.
Exactly.
So why would I charge them to taste the thing I hope they buy?
Well, maybe you want to do it on a broader scale to have a couple more, like you said, more expensive offerings out there to, then you sell that $50 bottle of wine.
And that's where, at least as it's currently written, I believe we morph into it becoming a tavern tasting or a restaurant or something like
Right.
that.
I appreciate the slippery slope concern, which I've heard before. I think, I mean, again, I think I'm not saying it's not a valid concern. I think we would need to do some work with the language to prevent exactly that from happening. But were we able to do that? I guess I'm trying to understand what the objection would be aside from the slippery slope.
Well, I guess I believe that once you start allowing the charge for a sample, you're already on that slope. That's my belief. I don't believe there's any other language you could write that would mitigate that. I think if you're going to be able to charge for a sample, you've now made a new profit center for an off-premises retailer. So, but one that by very definition means the person has to do it on premises. So that's where I'm coming from. I might be dense on that point, but I can't separate the two.
All right. All right. And on section 3, I have the same sort of, I'm sort of similarly perplexed as to your objection there. So again, all we're talking about there is under the existing Connecticut cafe permit, the permittee can sell Connecticut wine, offer Connecticut wine if they want, offer Connecticut cider, offer their own beer. And now we're saying if there's another Connecticut brew that you'd like to offer, you can offer that too.
It sounds pretty logical, and I know you don't like to hear this point, but there goes the slippery
Yeah,
slope.
fair enough.
You
Okay.
just heard two representatives from the Craft Brewery Guild say, we don't want to sell other Connecticut beer. We want to be able to sell beer, wine, and whatever for anybody. And that's made anywhere.
Yeah.
Well, stay in your lane.
Yeah, and we're not proposing that at
I
all.
hear you.
And frankly, I'm just as perplexed as they're at the brewer's opposition to what we are proposing. But I guess the concept, I think you and I have had these discussions every year. I'm not a big believer in the slippery slope, especially when I've seen us not go down that slope at all since I've been up here, despite my attempts otherwise. But you're just to be clear, your clients don't distribute beer.
Correct.
Okay,
They do
fair enough.
wine
But
and beer
you're here as an advocate for the entire
for
structure.
the 3-tier system.
Fair
Yes.
enough. Fair enough. Other questions?
So, thank you very much for being here. I just wanted to point out that we already allow fee-based wine education and tasting classes. We allow charging a nominal fee if the fee goes to a charitable organization. So what is the change now when it's limited to 1/2 of an ounce per liquor and then per individual liquor and then 2 ounces total?
I think in the first case, you're covering the cost of the educational component of the tasting that you mentioned that's under current law. In the second case, it's allowing a charity to benefit from it. Under this current law, this is a clear profit center, if you will, or goes directly to the package store. I don't think it's necessary. We already have we allow samplings. We allow them in a small quantity to allow a person to say, hey, if you like this, we're selling it here in the store, buy the whole bottle. To start charging and making a business out of charging for a shot and a half, I think is unnecessary. And again, I think it starts to go down that slippery slope.
Great, thank you. So based on that logic, then, if there were education given with the sample and they charged the fee, you wouldn't oppose that?
Well, yeah, but I mean, Senator, you and I both know you better be real clear on that, because you could say, let me educate you. This is good stuff. There's your education. Now give me $5 for the shot. So, you got to be careful with that.
Thank you. Are there further questions? Representative Yacarino.
Thank you, Mr. Chair. And just one question to Mr. Cafaro. I do agree, and I read the bill last night, and I read it again today, and I looked at the 1/2 ounce up to 2 ounces. And as a business, you would want that goodwill. And I think that business is going to lose its goodwill, because now you're charging. And if I'm paying and I say, you know what, I want more, I paid. I want a little more than a half ounce. And that, it could be a slippery slope. And the more you think about it, I don't think it's good policy. I think the way it works now is most people don't take a testing, take a testing or tasting, but I wouldn't charge. I do agree, Mr. Cavero. And I think because of the slippery slope, and also if you're paying, I think you're going to want a little more. And I think we have to think of those things. I have a business and I have things I do for goodwill. If I start charging my customers, the goodwill's lost. So I think you have to look at it that way in the overall picture. I don't think it's good policy.
Representative, thank you for those comments. It also reminds me of this. Let's say this tasting had 7 bourbons available. But the way I read the law is you're only allowed to sell as a tasting once or ounce and a half per customer or 2 ounces.
2 ounces.
So now I got 2 ounces of this bourbon. Wouldn't that allow me to buy 2 ounces of the next bourbon and the next bourbon and the next bourbon? I have 7 drinks in a span of a half hour that I paid, I don't know, $2, $3 for because it's a tasting. It goes well beyond the concept of, hey, you know, we're now selling this product. Take a taste, see if you like it. So you got to be careful with this. It could really get out of hand and go far beyond. And I know none of this was intended, but these are unintended consequences that I think everyone has to be concerned with.
I appreciate that. And I would have to think that most package stores are pleased the way they do it now. And I you just have to look off, again, goodwill. You don't want the confrontation of somebody saying, you know, I want this, this, and this, and this. But I appreciate your testimony and the thoughtfulness and your expertise actually in the subject.
Thank you.
Thank you, Mr. Chair.
Thank you, Representative. Other questions? Yeah, please, Representative.
Thank you. Good afternoon, Larry. How are you?
Good afternoon, Representative.
So I read it the same way. It really, Representative Yakarino, sort of, you answered my question through him, was the way I read it, it said fee-based tasting provided by permitted tobacco package store Friday of any spirit, meaning that you could go on from, you know, vodka 1 to vodka 2 to vodka 3. So by definition, on premise is food service or a restaurant, correct? Or do I have it backwards? I always get it backwards.
On premise is a restaurant.
Is a restaurant. So by its very nature, an off premise is a package store sells seals bottles of alcohol.
To
They
be
sell-
consumed elsewhere,
To be
with
consumed
the
elsewhere.
exception of a taste sample.
Right. So the minute they open up that bottle and they sell it, they become an on premise by definition.
Yes, I mean, you could argue they do, whether you're charging or not. Oh, you're saying because of the
Because of
element of
charging and
sale.
that they're opening. And
Okay.
then my next question would be, because I honestly don't know the answer, and I thought of it while everybody was talking, was, do they have the same liquor liability that, say, an on-premise does? Are they subject to
Dram
the same
shop?
dram shop and all that other
I
stuff?
believe they are, yes.
The package store has
Yes.
dram shop?
If you sell alcohol as a package store to somebody who's obviously, you know, inebriated or whatever, you are subject and subsequently does harm, you're subject to the same.
I'd be curious to know the rates that a package store pays in comparison to somebody that actually pours alcohol.
That I know.
But thank you. Thank you, Mr. Chairman.
Thank you, Representative. Other questions? Anyone online, MJ?
No one, Mr. Chairman, there's no one with questions online.
Thank you, Mr. Cafaro. Appreciate
Thank you
it.
so much. Bye.
What do you got, MJ?
Next up, it looks like we have Sam Abdigan, Sam A.
I've got Olivia Rinks on the agenda too.
They're not, Olivia is not on.
Okay, great.
Here.
Sam A, thank you very much. Afternoon.
There we go. Representative Rutigliano and honorable members of the General Law Committee, thank you so much for the opportunity to offer testimony today. My name is Sam Abdelghani. I'm a licensed pharmacist working in the state of Connecticut for 23 years now as an oncology pharmacist at Yale New Haven Hospital. I work in retail environment for about 10 years, and I'm currently the president of the Connecticut Society of Health System Pharmacists. I'm testifying today in support of SB 133. This bill was crafted with support and input from pharmacists from across all practice settings in the state: hospital, retail, and other practice setting as well, and in close collaboration with the Department of Consumer Protection and Drug Control. More importantly, the model that was proposed in this bill is supported by over 30 years of research, over 20 published trials that show that technicians who are well-trained are able to do product verification with higher accuracy than even pharmacists. The accuracy rate they reported in the literature is as high as 99.97%, equal or exceed pharmacists. So we know from research and others say that it works. We have data from 21 states today that they have that practice model that is allowed today as part of the scope of practice. I do support this bill today because expanding the role of pharmacy technicians will bring tremendous value to both patients and the practice of pharmacy in the state. For patients, I believe that delegating administrative tasks to well-trained pharmacists, and the training here, it has to be accredited training from a national organization. These technicians will, after the training and their years of experience, they will have a validation process. Following the validation process is an annual audit on their skills that they have to maintain throughout. So definitely well-trained and experienced pharmacy technicians will allow pharmacists to focus on patient medication-related needs, medication reviews, medication therapy management. This bill will allow pharmacists to spend more time providing appropriate counseling to patients about medication instructions, potential side effects, and any necessary precaution. The current workflow simply does not allow that to happen today on a regular basis in an efficient manner. In addition, having an additional layer of verification conducted by a trained pharmacy technician can significantly reduce the chance of medication errors and avoid potential harm to patients. On the other hand, from a pharmacy practice perspective, advanced technician role will minimize delays, interruptions, and in the dispensing process, which happen every day. This optimization will lead to improved efficiency within the pharmacy team, reduce stress and burnout, and more importantly, will allow for the expanded access for patients to get the services that they need today. This bill will enable pharmacists to redirect time to clinical functions in line with their education expertise and will establish a clear path with growth opportunity for pharmacy technicians. You heard earlier that we have a national shortage in technicians, and that without addressing that in a meaningful way, that will continue to get worse. We believe that this bill will give that technician a career path. They start as a technician, they move up, and that will give them an opportunity to advance not only in their job, but also gain more pay. Finally, this bill builds on the progress we made in advancing pharmacists' role in Connecticut with the support of this committee over the past few years. Thank you so much for your consideration, and I'm happy to answer any questions you may have.
Thank you very much. Are there any questions?
No questions online, Mr. Chairman.
Okay, great. Representative Acker.
Thank you, Mr. Chair, and thank you for your testimony. I had to step out for a little bit. I'm not sure if anybody else testified. I've got the crust of this now, so it seems like, because I'll go to my pharmacist and I'll see, 6 white coats behind the counter. By my understanding, there's a pharmacist, and then that pharmacist can oversee 2 technicians. So then the others back there might be another pharmacist back there with technicians, or
You could
what's the
have more than one pharmacist depending on the volume of the store, but essentially this bill provides coverage for everybody working behind the counter. Everybody with a code or a name tag now have a role, starting from a clerk, and kind of designate what the clerk can and cannot do. I think there's a question earlier about the value. I have that. It's actually protecting consumers at the end of the day, because now we're saying that clerks can only do that much and not beyond because they're not trained. And then there will be a pharmacy technicians, advanced pharmacy technicians, and then pharmacists. So really define the role of everybody behind the counter so everybody function within the scope of practice and training.
Because I know that there's a section that I go into the pharmacist that's asked the pharmacist a question, and you go to the side booth, and that would then be able to give that pharmacist the ability to come and have direct conversation for as long as it takes. And then the advanced technician, a pharmacist technician, would be the one kind of in the
Working on administrative tasks.
without supervision.
So thank you so much for making this comment, because I don't think we spend enough time today talking about what pharmacists will retain. The questions on the side, anything clinical, drug utilization review, filling the actual prescription, any clinical judgment, counseling, all that will be retained by the pharmacist. None of the other roles will actually be providing this information to patients. They're not trained to do so, and we want actually give pharmacists more time to focus on that work.
So you look at it, this as a career advancement level. Essentially, someone starts at whatever, if the clerk wants to be the clerk and then direct person to the booth, then the person, you know, that's actually dispensing and putting together would be more of the advanced pharmacist technician.
Correct.
And then the next level would be the pharmacist, and you're kind of building that career ladder.
Correct. And this is the beauty of the model that we are proposing here in Connecticut. Other states focus on a specific task. We are building a pathway with a career growth opportunity for those folks who don't end up being a technician for 1 year and do something else. We want them to pick pharmacy tech as a career and see a path to move forward in that lane.
What is the pharmacist itself? What is the I guess the amount of pharmacists, is it growing, lessening, overworked? What is it?
All the above in a different combination. We are seeing a reduction in the number of enrollment in pharmacy school across the country. So in terms of numbers, we know that the numbers are not growing and the need expanding, a patient getting older and more medication. So this is one way to actually maximize the workforce that we have on the pharmacy side. Again, we think that changing the model will make the practice of pharmacy, even on the retail side and the hospital side, more attractive. And by building something like we have today, we'll get more people getting into the pharmacy.
Thank you. Thank you for your testimony. Thank you much. Thank you,
Thank you so
Mr.
much.
Chair.
Thank you. Senator Ciccarello.
Thank you. And just a quick question. You mentioned that this bill proposed would help the end user, the customer, be able to get on the phone with a pharmacist. I know if someone calls, it takes a while to get on the phone with someone, or if they go to the pharmacy, there's a long line. Or last year, as we discussed, they would go to the pharmacy and it's closed, and it was unexpected. Do you think this would help that problem that we're seeing here?
Well, one, you'll definitely help with the pharmacy closer indirectly. So by having a stable work environment that is not stressful, by having enough support that are trained, you will have pharmacists working in retail and attracting more pharmacists to work in a retail environment. What you see in terms of delay, pharmacists have to do a function and then jump to another function and a third one, not the most efficient way. By having that advanced technician role will streamline the process where from the time the prescription is filled to the time you get it, it's much shorter. And again, all that would be done with technology, barcoding, so without minimizing or sacrificing any safety.
Thank you. And just one more question. Now, an advanced tech would be the one below the pharmacist, correct?
That's along obviously with pharmacy students will be below pharmacists, correct?
Would the advanced tech be able to fill prescriptions without a pharmacist on site?
No, I mean, again, maybe it's something we didn't talk about. All that has to happen under the direct supervision of a pharmacist. It's written in all our laws. That will never change. So a pharmacist have to be present supervising that role.
Thank you. I just want to clarify. Thank you.
Thank you so much.
Thank you. Are there any further questions? No. Thank you very much.
Thank you so much. Appreciate your time.
Next, Jude Malone.
Good afternoon. My name is June Malone. I'm with the Connecticut Beer Wholesalers. Senator Maroney, Representative D'Agostino, Senator Ciccarelli, Representative Ritigliano. I just thank you very much. I'm here today in opposition to House Bill 5149. That's, you know, I just really want to say, Representative D'Agostino, thank you. And I respect you a great deal. And I so appreciate Senator Maroney, Representative Ritigliano, all the time that you spend talking to us about this. The one thing that we have said time and time again, our franchise laws are all we have. That's it. We have a truck and a building. And without franchise laws, we have nothing. So I so appreciate that when you asked us last year to talk to the guild, and we did that, and they clearly said they want to be able to move away from us, and they want to be able to dual. And she actually said we should be able to sell our own products. And so I understand how we got here today, right? Is that it sounds, and someone that I respect a great deal before me said, it's not really, doesn't sound like that big of a deal. To us, 5 mile, the sale of kegs, 5 miles, that's the first diminishment in statute of our franchise laws, other than the provision that you clearly mentioned. And I want to be very careful because I never want to frustrate you. I know I do, but I don't want to do that today. So we're going to try a new path. So, right. So, okay. So, there is that provision, and we're not going to talk about that. And I understand how we got here, right? Somebody called a brewery, needed something after a certain time when we couldn't distribute it. They did, and they got reprimanded from their wholesaler. And I would sit here and say, I'm sorry about that. We would say, the people in the Connecticut Beer Wholesalers Association, thank you for doing that and making sure the customer got what they needed. We can't always be there. So, you know, I would just ask you that dual distribution for a beer product is very different than maybe other products that are dual. You heard that today. Well, other products are dual. Beer is not dual for many reasons. You know, and I think Mr. Gargano said it best. Well, it's a start. We want more, and we know that, and we don't want to go down that road. You said to us, Representative D'Agostino, this committee, and I truly believe it, has been so thoughtful about what everybody can do. And we just ask you, and we tried to come up with a solution. I know you didn't like it, but what they can do without changing any statute at all today, change the label, don't assign it, and you can distribute that new keg anywhere in the state you want. Because remember, they can distribute, they can sell from their facility, they can do most things that no one else can do. And we don't begrudge that on them. But dueling and our franchise is just aligned. We just ask you, please don't cross. So, you know, I want to say that we don't always want to say no. So Section 3 to us, the craft cafe permit, if that's the way they want to proceed, we support them in that. I do want to just take a second of my time to respond to some of the wholesale things. Just one, just so that you know, is that when we receive a product on our floor, we have to, by statute, pay that brewery in 30 days. That's our credit law. We pay them. We pay the state of Connecticut. We take all of that responsibility on. They are, if that product, as someone said, does not sell, that is on us. We lose the total financial amount of money, whatever we don't sell. We can sell at our cost, but we do not, and there are promotional things that we try to share with them, 50% here, 50% there, but we take on the financial cost of the product if it isn't selling. So that's number one. Number two, Representative Rutigliano, you were right on point. The manufacturer has the absolute distinction of where they want to sell. They can carve out, Beard could carve out, I live in Mystic. He could have all of Mystic. He's in Stonington. He doesn't have to have a distributor there. We have contracts now that carve out towns. they're not by county, they are at the discretion of the manufacturer. So, you know, and there might just be some misunderstandings. We're happy to have those kind of dialogues, but when we're talking about dueling, that's just an area that unfortunately, I'm so sorry, that's just something we can't come to an agreement on. And I hope you understand. And that's really all I have to say.
No, look, we do. I don't. I'm not frustrated with you or your clients. If I was representing your clients, I'd take the same position. You know, it's what we see up here all the time. You protect your advocates to protect what you guys have. My frustration is obviously with the law, and as we've heard time and time again in this committee, the fact that we have a statutory scheme that is born of a situation that existed literally almost 100 years ago, when there was this complete uneven distribution of power between these large scale manufacturers and small distributors. And that's why we had a scheme where we have the sections in 3017 and the franchise laws and a lot of the protections built into our laws to protect your clients. Almost 100 years later, you're seeing that dichotomy switch and the law hasn't moved. Now, I appreciate what you're saying, that contractually you have, and that's important. And look, if nothing else comes out of this and the discussions we've had over the last few years, the fact that you're sitting down and meeting with these folks, I think is definitely a positive. We as a committee want you guys to continue to do that, because we don't want to be sitting here deciding which thumb of the scale to put on, or thumb on the scale for commercial parties. You guys should be able to work that out yourselves. And that's my entire point, which is I think the statute should be neutral on this sort of thing. And in my mind, they're not. But your position is appreciated, and we understand that's where you guys were coming from on this. At least you guys spoke about it. So that's section 1. I appreciate the comments on section 3 as well with respect to that. So I mean, I think we understand where you're coming from. I know I do. And again, I appreciate that your members sitting down, talking to us on several occasions to work through these issues and have pretty robust discussions about where I was coming from on it, where they're coming from on it. We totally get it.
We're in a much better place.
You know,
aren't we?
the one example
Yes.
you gave is the concern where, you know, the small manufacturer goes out, delivers that keg, and the wholesaler uses the weight of the statutory scheme to come down hard on that manufacturer. That's what leads legislators to react, and why we're reacting there. So I would hope that the message to your members is that shouldn't be happening, that people should be making contractual accommodations rather than trying to use an existing statutory scheme as a commercial hammer. That's not the intent. That's not what it should be. And in my mind, that's what needs to change if people are going to continue to do that. So that's my 2 cents. I don't actually have any questions for you. I think you stated your position clearly and effectively. I know the members do though. So let me go to the rankings and co-chairs first. Are you good? I mean, yeah, no, you ask your questions. If you want to, I can come back to you. Okay. Representative Ackert? Yeah.
Thank you, Mr. Chair, and thank you for your testimony. You know, I'm frustrated with how this came about. If, you know, somebody's keg ran out and they were in need of that one product or whatever may have happened on that. I can tell you that there's been times that maybe I choose popular beers at times that my first choice was out, my second choice was out, and I had to go to a third choice, which is fine. I got to try a different kind of refreshment. Do you believe that what you do and what you provide for these makers, these manufacturers, is a value to the economy and a value to them?
Absolutely, because they make beer and they're good at making beer, and we're good at delivering beer. And it's hard work, and it's something that not everybody wants to do. And we have really good relationships, and we value those relationships. You know, sometimes they need a little bit of our help. We help them. Now, are we angels? Is there problems? Listen, everybody has problems, and everybody in some kind of relationship, but we say this all the time, is that if there is and I can only speak for my members, and I'll tread lightly on this so that I don't break any laws, but it is clearly that if someone doesn't wish to be with you any longer and the relationship isn't working, maybe sometimes and I don't want to pick on any one person, but with beer, let's say, their beer is doing great in Mystic and Stonington because we like our beer in Mystic. But then you get to, Fairfield, and now they're not a local brewery anymore. And that might be a different challenging opportunity for that wholesale, and it might not just work. And we would say, we want you to find somebody that can do that work for you, and we would release you. And we have demonstrated many times when we've had these discussions that that is our policy individually, not as a group. They make that decision individually, but yes, because they can't do it. They look to us for the laws. We do all the bottle bill, we do all the taxes, we do all, the cooperage, the kegs, picking them up, all of that things for them. So, and they supply us with good beer that Connecticut residents want. And we want to continue that relationship. And again, if it's not working, they should be able, on a contractual basis, to release and find a wholesaler that they feel more comfortable with.
Thank you. Thank you. I appreciate it. I'll continue to listen to the dialogue. Thank you, Mr. Chair.
Thank you, Representative. Other comments? Dave? Representative Tigliano.
Thank you. Thank you, Mr. Chairman. I just have a couple of questions just for my own. When you have do you know the percentage of beer that gets returned to Connecticut breweries after a certain amount of time?
We don't believe that we return it. It's because we've paid them for that beer. When it hits our warehouse floor, we paid them. It's now, we have all the financial responsibility. We have some things that we can do, that we can sell at our cost to try to move that product. But so I don't see that same scenario that we heard testimony on.
My understanding is that yes, you have to pay the manufacturer within 30 days, right? For the beer that you bring into your warehouse. And if you don't sell it within the determined amount of time, I don't know if it's 90 or 120, maybe Bill knows, that you're able to charge back a percentage of that purchase you made back to the brewery.
From my understanding is that it would be a contractual relationship, but from my understanding, we don't do that. Yeah,
I mean, you do it, but that's,
maybe it's a
my
contract.
question, my
Contract.
question
I
is
don't think
that
we do it.
this is what I had a question. If you have to pay them within 30 days, how do you actually get your money back if you return the beer? Is that sort of off of a future purchase, or do they have to cut a check and send it to the wholesaler?
So I would say you seem to know a little bit more than I do. So I know when I'm outwitted here. So I should just probably say, why don't we have I will
We could do
find
that.
out and have a conversation,
actually-
because I certainly don't want to give you.
I have to
bad
be surprised. So somebody who's been in the beer business for a while, I actually did not know that was a thing. And I was shocked I'm sort of in search of how the mechanics of that work. Because quite frankly, a wholesaler can go out and buy tons of beer from somebody and intentionally not sell it, and for whatever reason, and then all of a sudden that they have to take half of it back right at its expiration date. So I think about it, I'm like, man, that seems odd, because I don't believe the liquor people have that issue, because it kind of doesn't go bad, right? It gets better over time. But not all of it. Not all of it.
The thing is that possibly it is a contractual agreement with a wholesaler and brewer and that piece, and not everybody does that, because that is not my knowledge that you actually do it. Like our, born on codes are something that, well, we can't consignment sale, and because of that new law, that consumer protection, and we appreciate that, out of code beer, we have limited ability to pick up now. So I would just have to say that it's probably a contract, and I have not heard of it. And I actually, Representative, called one of our members to ask them what happens in that situation, because I certainly don't want to sit here and provide you with false information. And they shared with me, they own that because they've paid for that. And and it must be on a contractual basis, but I will certainly, I look forward to further conversations about it.
No, no problem. I'm just curious about it. That's all. Because
Thanks.
listen, beer goes bad. So I would imagine in your industry, you have to handle it well in general because you have a perishable product. Not everybody has to deal with that. And the mechanics of it interest me for some reason. But I'll reserve for a conversation offline and we can get up to speed. So thank you, Mr. Chairman.
Great. Thank you. Representative Brown.
Thank you, Mr. Chairman. Hey, Jude.
Hi.
If you're a Beatles fan, sorry. I just have a couple of questions. So in this situation that I guess ignited this piece of legislation where they weren't able to deliver the keg on time, how often does that happen? If it's a reoccurring issue, let us know. If it's a rare instance, maybe that's the case.
Yeah, well, like I learn so much every day from things. I'm not in their shoes. I'm not at their wholesaler facility every day. So when I heard the story, I called each one of our members. We're a small association. There's other wholesalers out there. I can only speak for, we have 4 wholesalers in our association. And they, I think the gentleman from Beard said this, is that it's a partnership, right? We're not always there. I can't tell you the frequency that happens. We try to do our very best to get that product there. And on circumstances where we can't and they do, every one of them said it happens. It happens. And there's a paper trail and we take on the paper trail and we just make sure that everything, we close the loop on that. So, I hope it's not a lot, because I think that we try to be very conscious about that, but things happen, yeah.
No, I appreciate that answer too. And just a final question. I think you brought it up and the folks brought it up before as well. In instances, you mentioned that it's a partnership. When you sign these agreements, it's a partnership that we will do X and you will do Y. And then you said it's a partnership. And so you want to be on the same page and you want to be in business together, right? That's how partnerships work. Both people. So in the instance where one of them decides, let's say, I no longer want to be in this contract. We know that they have to go before the Liquor Commission, hire an attorney to make sure. How often of the total folks who are saying, I want to terminate my contract on a yearly basis, how many of those are let out of the contract either voluntarily or has to go through another process, which through the Liquor Commission? And how many of those are successful? So if you tell me 25 total people attempted to terminate their contract, but it was unilateral. And so the other side didn't agree. Of those 20, 5 of them were granted relief or separation from the contract, and it must have been due to some serious circumstances. Do you have any information as to the percentages that are actually relieved from the contract or that even attempt to break the contract?
Thank you so much. That's such a thoughtful question. And as we prepare to have meetings this fall with some of the leadership of the committee, I asked that same question so I can get you from our members, how many we released last year. And I think they all shared with you, it's like a marriage. And I'm divorced, so I should know this. Is that when it doesn't work, you just want out, right? So, okay, so that was my situation. So, but anyway.
Thank you, Jude.
I'll
stop there before you learn anything else. Thank you, Mr. Chairman.
Thank you.
Thank you. Other questions from committee members? Anyone online, MJ?
No one online, Mr. Chairman.
Everyone's afraid.
No, not at all. All right, thank you. We appreciate where you're coming from.
Thank you.
Who would you like next, MJ?
Up next on my list, I have Greg McKenna, who's online.
Great. Let me know when he's in the room.
Yes. He is joining right now, Mr. Chairman.
Great. Mr. McKenna, can you hear me?
I can hear you and hopefully you can hear me.
Yes, and see you. Great. You're on.
Okay. Well, thank you very much, members of the General Law Committee. My name is Greg McKenna, and I personally do want to thank you for your time and dedication to the residents of Connecticut. You know, you appropriately said that your job is to really work for the people of Connecticut and the constituents, and how each law really has to change for the benefit of the residents. And what my 3 pharmacies do in the state of Connecticut, we are much like Ed Schreiner's business. We service the assisted living, independent care, and as well the burgeoning and growing medical at home market, where we really have to coordinate the multiple physicians that people use, their multiple medication orders, changes, and we have to coordinate, even help them coordinate their doctor's visits and getting refill needs, and then putting this into a packaging so that the people can remember to take their medications in appropriate fashion. And we've actually, in conjunction with Middlesex Hospital, we've really done some programming where we use this in the surgical center sites so that people come out and can really control the amount of opiates and pain medications that they need, and actually can get through surgery much quicker. And after we do all this, we deliver it right to their homes. Now, the problem is in the state of Connecticut, right now, we create all these wonderful systems for people that, and our average client uses almost 13 different medications, really 30 different pills a day, to manage their blood pressure, cholesterol, diabetes. And the problem is right now in the state of Connecticut, we're able to put those packages together, in fact, the average person takes almost 3 hours to really go through every doctor and get the medication correct. To then do that packaging and then find the ability not to correct any changes that the doctor makes 2 or 3 or 1 week later, 2 or 3 days or 1 week later, we can't take that packaging back right now and take out the medication, as Ed Schreiner might have told you about, the change in the same blood pressure medication, just a different strength. And he couldn't take out the 5 milligram to put back in the 10 milligram tablet. So Ed was forced to give the 10 milligrams on top of the 5 milligrams, and the client wasn't sophisticated enough to take the 5 milligram tablet out. So he ended up taking 15 milligrams a day and ended up in the hospital in very short order. Well, I can share with you that that happens too many times during each week and month in the state of Connecticut in multiple pharmacies. And I really would like to, request that you affirm this bill 133 and allow pharmacists to be able to take back these packages, make the changes, and then re-deliver them out to the client in a very quick manner so that the client can take the appropriate medication, can utilize the benefit of these specialized packaging. It's almost foolish to even have the specialized packaging if you can't make the changes as a day in, day out basis. And I can share with you that in our 3 pharmacies, I currently do over 13,000 people in the state of Connecticut that utilize this service, and a fair number in the assisted living market, but a fair number that are at home and want to stay at home. And, obviously that is not only an advantageous situation for the elderly person that wants to stay in their home, it's advantageous for the family member of that elderly person for them to be there with them. And it's cost effective to the total system because the person now doesn't start going into assisted living center where we actually provide those packaging to the assisted living to the nurses, but then the person has to pay an additional amount to the nursing home to manage their medication. So it makes a lot of sense to allow the pharmacist to do it and save tremendous dollars and time. And as many nurses will tell you, it is not their job to figure out which tablet is which. And they don't have that time. That's not their job. It's the job of the pharmacist to sit there and make sure that the right medication is given to the right person at the right time. And this packaging allows that to happen.
Right. Thank you very much.
Yep.
Are there any questions? Okay. Hearing none, thank you so much for your testimony.
Well, thank you.
Okay, next, Christina Hatfield. Okay, button's already on, so you don't even need to push the button.
Awesome, thank you. Okay, so good afternoon, chairmans, ranking members, and distinguished members of the General Law Committee. My name is Christina Hatfield. I'm a practicing pharmacist who moved from Kentucky to Connecticut 2 years ago and currently residing in Colchester, Connecticut. I am the director of pharmacy at Hartford Hospital and the co-chair of the Legislative Committee for the Connecticut Society of Health System Pharmacists. I appreciate this opportunity to provide testimony and support for the advanced practice technicians referenced in Senate Bill 133. In my role as the director of pharmacy, my top concern is providing safe and effective pharmaceutical care for all of our hospital's patients. I work daily to develop and optimize processes that will improve the delivery of said care. I support this bill because I strongly believe the development of advanced pharmacy technician roles will aid in the provision of safer care. The practice of a technician verifying the quality of another technician's dispensing process has been studied since the 1990s. In response to the safety demonstrated in these studies, 21 states have already allowed advanced technician services in pharmacy settings. Since I came from Kentucky, I have experience implementing and observing the positive impact to patients that advanced technicians can provide. In my hospital in Kentucky, we implemented advanced technician roles in the summer of 2020 when the department implemented technology to allow barcode scanning on dispense. Following this implementation, several positive trends were noted. First, there was a significant decrease in the number of dispensing errors that our department had. Second, there was no difference in the error rate when an advanced pharmacy technician was verifying the accuracy of a medication compared with a pharmacist. Third, the pharmacy technicians were more efficient in the verification process, causing a decrease in our late medication administrations. On review, it was determined that the efficacy increase by the pharmacy technicians was not due to a less diligent review of the medications. The pharmacy technicians understood the workflow better and had improved prioritizations of which medications to dispense first based on delivery patterns. Finally, the implementation of advanced technician roles allowed the pharmacist to prioritize direct patient care activities, including a focus on discharge medication counseling. Another positive outcome from implementation of advanced technician roles is increased job satisfaction for pharmacy technicians and pharmacists. As Sam mentioned, this is especially important due to a pending shortage of trained pharmacists. The U.S. Bureau of Labor Statistics reported a 13% decrease in the number of employed pharmacists in the state of Connecticut from 2020 to 2022. Both pharmacy schools within Connecticut have also reported decreased enrollment numbers in 2022. And that trend was replicated nationwide. Pharmacists are currently the most accessible healthcare providers in the United States, and a pending shortage of trained pharmacists will negatively impact patients throughout Connecticut. Advanced technician roles help pharmacists reduce burnout by shifting responsibilities in a safe manner, keeping these essential healthcare providers within our state. Thank you for the opportunity to comment on this important legislation. While we appreciate that there might be some concerns on the language of the bill, we strongly support the concept. We look forward to further collaboration to remedy any concerns and promote the passage of Senate Bill 133, because this bill will help us keep jobs in Connecticut, increase access to healthcare, improve health equity for our Connecticut residents. And with that, I'm happy to answer any questions.
Thank you very much for your testimony, Senator Ciccarella, and then Senator Kissel.
All right.
Thank you very much for testifying. As you stated, you were from Kentucky and they introduced this there. and you were reading some statistics. Do you have that data? Did you submit that data when you give your written testimony?
Which data?
The first three, you said the number one, there was less,
No, because that was internal data from my hospital in Kentucky, which I did not bring with me when I moved to Connecticut. So what we did in Kentucky when we implemented this advanced technician role, which has a different name in Kentucky, we actually did internal tracking of our errors. So every hospital usually has a medication error reporting system, and we track errors before they reach patients, errors that reach patients the whole way through. So we daily tracked our errors on the pre-implementation side and then tracked them on the post-implementation side. But all that data was internal, and I didn't bring it with me when I came to Connecticut.
got it. And then one more question. By having the steps up, did they see an increase in the amount of pharmacists as years went on after implementing this? As far as having the clerk and then tech and then advanced tech and whatever they were calling it there, but did you see the problem being solved where there'd be more pharmacists coming into the profession?
I think it stops pharmacists from leaving the profession. So one of the issues that we have is pharmacist burnout. And one of the key components of that is having too many duties and roles to do at a time. It's actually also one of the reasons why the technicians were a little bit better and more efficient at doing the verification process. So I think it makes for understanding if you understand the dispensing process, and I'm going to keep it to a hospital because that's where I have the most knowledge. So on the dispensing process, first, when a physician writes an order, the pharmacist reviews the order to make sure it's clinically correct. We look at allergies, we look at age, we look at dose, indication, all of that. If everything looks correct, we verify the medication and say that it's correct, and that starts the dispensing process. So first, a technician goes and they'll pull that medication, and they'll pull it from a shelf or from a system, and then they'll bring it forward with a label for someone to verify the accuracy of the dispense. That's kind of the key component of what we're talking about in this legislation, is who is verifying the accuracy of that dispense. In this legislation, and what we did in Kentucky, is that when you're verifying the accuracy of that dispense, you barcode scanned it to make sure it was correct. So you had the patient label, you barcode scan the patient label, then you barcode scan the dispense. For a lot of systems in the hospital, not only do you barcode scan there, but you're also going to either barcode scan into an automated dispensing system, which I would consider like a vending machine for drugs that a nurse uses to pull things out patient specific. But then nurses also barcode scan the patient's wristband, so their patient identifier, and the patient before they administer the drug. So we have lots of different places where these errors can't go through. By implementing barcode scanning on verification of dispenses, that's where we saw a majority of the decrease of our errors, because the barcode scanning rate is just so much better. One of the things I really like about this legislation compared to the Kentucky legislation is that it requires barcode scanning on dispense to implement the advanced technician roles. And I think that's a really important safety factor.
Thank you very much for answering those questions.
Thank you. Senator Kissel.
Thank you very much, Chairman Maroney. Welcome. I have to ask this question. Are you related to the famous Hatfields of Hatfields and McCoys?
Okay. My father-in-law tells me that they are from the lover side, not the other side. So
Good for Dad. He's a lover, not a fighter. I appreciate your take on this proposal. Would you say, first of all, you said that there was a decrease in folks going into being pharmacists. I noticed, first of all, sister-in-law is a pharmacist, but also just observing the trends of time. You said from like 1920 on, well, we have the pandemic and all the stressors that caused, as well as, we have the baby boomers aging out, right? And so that just means a lot more people getting prescription drugs, and so I saw like people being very demanding. It just seemed like it shifted in the last 10 years. And so between the pandemic and what seemed to be a greater swelling of folks that need prescription drugs, which of those two, both, do you feel sort of added to the stress on pharmacists, and why folks may not choose that as a career path?
I mean, I think there's a lot of different reasons why people won't go in or are hesitant to go into healthcare right now. And it's not just pharmacy. There's a lot of healthcare professions that are struggling to find people to enter their profession. Part of it, I think, is the stressors by the pandemic. I mean, it's a lot harder when you're going into a healthcare profession and you're a frontline worker and you're going in every day, and you have other people that Like my husband is a software engineer. So, it snows, he works from home. If it snows, I go into the hospital. And I think getting people into those roles can be a little trickier. And then part of it, especially if you're looking at pharmacy school, there is a cost barrier, especially with inflation and other things going on. It's definitely a costly profession to enter into, and sometimes there's that cost barrier. I think it's one of the reasons why the technician career ladder is also so helpful, because if we can get people started first as a clerk, and I support the role of a clerk, because I think when people enter pharmacy, they have an idea of what it is, and it kind of gives them a taste for what healthcare is. And then if they continue to grow in that, you can grow them into a pharmacy technician. So that's going to be the person that initially pulls that med. So they're not doing that verification step, but they're just kind of pulling it, counting pills or putting things together into a bag to kind of send it to a nursing floor. And then the third step, if they are really into it, you go to your advanced technician roles. These are your really strong techs that can really help you move your processes forward, move things forward. And then a lot of those technicians do end up going into pharmacy school. And then if they've been at the company for a while, there could be tuition reimbursement or other ways to help them. Then a lot of the pharmacists can also help mentor them through the profession. So I can see it helping in lots of different avenues. But it's definitely hard out there right now to attract pharmacists into pharmacy school.
I very much appreciate that answer. And I was going to ask you about the clerk proposition in this bill as well, but you addressed that. And I just met with a lot of folks from my community colleges, and healthcare is definitely an area where there's a huge demand, and we're looking at ways to attract. And actually what you created was a sort of an interesting paradigm, because as you were speaking and sort of creating a ladder now formula, it reminded me of apprentice, journeyman, master, the whole tiered system that we have in other professions, electricians, plumbers, things like that, which in many respects has worked well. So, I do still have a little bit of concern regarding the consumer interaction with the clerks, but if the clerks, let me just ask you this. Do you envision the clerks being utilized so that they will see behind the counter? They're not just going to be isolated in the front as the interface with the consumer, but that you said that that's sort of a first step to see what it's like in the whole pharmacy area. Do you see them like interacting with the technicians and the pharmacists so that they're not somewhat isolated, but they would be the person in the interface, and that's sort of a good taste as to what the business is all about as far as prescription drugs? Do you envision it that way?
I would envision it that way, just because, if you've been in the footprint of most retail pharmacies, and that's where a lot of the clerks would start off, the footprint's not very big. So you would be interacting quite a bit with them, and it kind of gives them that initial, you're interacting with patients, but they don't have to take on that clinical component. And a pharmacist, to become a pharmacist now, you are getting a doctorate degree in the United States. And then I think a third of the pharmacists in the United States are also board certified, and a good portion of them have a second year, sorry, I misspoke. A third of the pharmacists in the United States have done a residency. A good portion of them are board certified, and then some of them do a second year residency. So we have a strong clinical training, and those are the people that you really want to answer your questions on your medications. I think we want to make sure that there's the delineation of roles in the pharmacy so that people know, who they're talking to, and that this person's educated to answer those questions. And I feel like this will also help with that.
Well, thank you very much. It's a quickly changing field, no two ways about it. And just sitting on this committee for the last few years, I've seen rapid progress being made in this direction. And certainly we are reaching a critical stage where right when we're going to need more and more folks in this field, we're losing folks in this field. So I think if Connecticut's smart about moving forward under the direction of our chairs and ranking members and everyone else in the legislature, I think we can end up doing well coming out of this turbulent time. So I appreciate your testimony. Thank you very much, Mr. Chair.
Thank you, Senator Kissel. Representative Brown, do you have a question? Okay, Representative Brown.
Thank you, Mr. Chairman. And thank you for your testimony today. I want to go back to what Senator Ciccarello was asking in terms of the data. I know you said you didn't bring that data with you, but I think you were referencing something like I think it might have been the previous speaker, 99.97% accuracy based on that data. Was that only in the hospital setting, or did that also apply to retail locations? Because for me, my pharmacist is in a Stop & Shop, right? And so do those pharmacies also have that same type of accuracy rate?
Yes, from the studies I've seen, it's been good accuracy rate. I can't say it's exactly that 99%, but I've seen good accuracy rate, and there's studies supporting it in both the retail settings and the hospital settings.
Okay, thank you. And just if this will help with anyone's concern, I was a part-time pharmacy technician back in the day. So whether that helps or doesn't, I just wanted to put that out there. Not 99.9.
No. Yeah, I mean, I think one of the things that I also think is really good about this bill compared to the one that we had in Kentucky is, the requirements of 3 years of, practice. For a technician to stay in for 3 years and to be board certified, I mean, to be board certified as a technician, you have to take a test and you have to keep up CE. And that test is not easy. There's a lot of math on it, drug names, just different interactions. There's things that they have to do to be able to get that board certified and to maintain that board certification.
Thank you. And I think another thing to point out is that the commissioner of DCP does have to put forward regs for testing
Mhm.
as well as specifically stating the duties. So it even goes beyond that. So, and it's a shall on the regs. So they do have to do that, whereas the clerks, it's a permissive on the regs. So
Mhm.
thank you very much
Thank
for your
you.
testimony. MJ, are there any questions online?
No questions online, Mr. Chairman.
Okay, thank you very much.
Thank you.
Is there anyone else here who hasn't signed up who would like to testify? If so, please come forward and just state your name for the record, and you'll have 3 minutes.
Hello, everybody. My name is Mike Teed. I'm the president of the Connecticut Brewers Guild and co-owner of Black Pond Brews. I just wanted to speak really quickly to kind of clarify a few things for you guys and give you guys a better understanding of kind of what we're talking about. One of the first things I want to mention is that I think that, I know you guys have put a ton of time into this, and we really appreciate all your efforts. And I think that our kind of seeming stance of, being in opposition is more of a formological issue than anything else, in the sense that if your website had a thing that said support with alterations, I think you would have seen a lot more brewers file under that category as opposed to anything else. We did talk to legal counsel about this kind of stuff, particularly the Brewers Association. They, red flagged some aspects of this as currently constructed, and we also reached out to DCP, and they were kind of concerned about the language, and how that would kind of span out. But I have, the utmost respect and admiration and, all the rest of it for you guys. I know you guys will be able to do something that will work for us. And we do really appreciate that you guys have done so much for the craft beer industry over the years, in the past, as well as in the future. So I wanted to also just kind of rapid fire through some of the questions that you guys had. Unfortunately, I apologize in advance. I'm a bit of a nerd with this kind of stuff, with some of the formological stuff. I teach for Sacred Heart in the Brewing Science and Operations Management class. So I actually happen to know a lot of the questions that you guys brought up. I think the big thing that, and part of the reason why we're here and we're having this discussion is because nobody's brought it up so far, as minimums. So with distributor agreements, when a distributor sends beer out to any kind of account or whatever, they can change the minimums that are sold. So a good example of how this works and why this is a problem for our industry is that, and another thing too, we tend to, and I teach my students this, if you have a brewery and you sign on with a distributor, you still need to have a sales rep on staff. So you still, on your payroll, even though the distributor is getting paid 20-30% for their cut for everything, you're still having someone on staff to rep your beer out in the wild, basically. So it happens to us where our sales rep will go out to an account, they'll actively sell our beer to a package store, or a bar, or restaurant. What'll happen is then the distributor, even though we've sold, like, let's say 2 cases, it hasn't met the minimum that the distributor requires in order to actually send product out to that account. So what ends up happening is it'll get deferred by another week. So, and in the meantime, that bar restaurant needs product, and so then they find somebody else to fill that tap or to fill that space on the shelf. So even though we're paying somebody to go out and they do sell our beer and people want our beer, the issue is that it isn't being fulfilled in the back end. And because of state law, we're not allowed to kind of do anything on the back end to kind of hold them accountable and change the agreement or anything else like that. So the minimums is like one of the big issues, and they can change that. So we actually saw this past holiday season where some distributors went from a $300 minimum up to a $700 minimum, which meant that a lot of package stores, especially the mom and pop places, can't afford to meet that minimum. So, you know, when we're going out and we're selling beer and product to places, and we can't, you know, they can't meet those minimums, they're not buying our products and putting them into stores. I'm going to rapid fire through a couple other things. Representative Retigliano, we can set up agreements that are more specific, but that's also assuming that you do that to begin with. Once you're in an agreement, that's the end of the game. So that's part of the reason why, like, we can't hold these people accountable down the road if they're not fulfilling, you know, again, obviously you can do the, you know, go through the process that we described earlier, but it is lengthy and expensive. And I will say from my experience, you know, we've been in business for just about a decade at this point. I personally know of only 4 or 5 breweries that have fought against their distributors and, you know, either gotten out of the contract or something else like that. Also as for beer being bought back, usually the way that it'll work is they have to do a credit memo. So what'll happen is the next order that you send out to a distributor, they'll take that amount off that. So let's say you send out $10,000 worth of beer and they have to send back $2,000. Now you're only making $8 because they took that off that invoice that first time. So that's how that back and forth works with that. How often do kegs not get delivered? It happens with some regularity, and a lot of it has to come with the minimum orders. If they don't meet those minimum orders, then those kegs don't get delivered, and then they sit on the shelves for a lot longer. Yeah, so, yeah, and lastly, real quick, Representative Yacarino, you mentioned oversaturation. We are 25th in the country for the number of breweries and 25th in the country for beer consumption. So there's actually a ton of room for growth for our industry. So that isn't really a concern either. And in fact, we just signed on with sending our beer over to Sweden. You know, so there is a very large volume at that. So there is a desire for our products, not only here in Connecticut, but also internationally. So that isn't a concern from our side either. So thank you.
Thank you. Representative Retigliano.
Thank you, Mr. Chairman. So the chargeback, or whatever the proper term is, does happen. Do you know the frequency of which it happens?
So we have set up a poll with our members, and we don't have the data right now, but it's something that we are gathering, and we'll continue to gather as time goes along. So we have some actionable data for you guys to actually, you know, illustrate the frequency with which this is happening. So,
Are other people, maybe not in the liquor space, but in any space, are they able to do that? Say you sell another perishable product, I don't know, to a grocery store, are they allowed to do chargebacks? Or
I can't comment on that. I'm not sure
Just
about other
curious.
industries, but I do know for a fact that it does happen in ours. So.
So I do understand what you're talking about. When you say a 2-case minimum or something like that, that's set by the distributor for delivery. They're all doing it now, right? I mean, even everything's changing all the time. Is there a specific change in your mind, or that you could write outside of you saying, oh, we should be able to get out of a contract no matter what, just because I say I don't like you, that would help your industry with the wholesalers?
Yeah, I think that the steps that you guys are taking and are really positive, and I know even the Brewers Association is part of the reason we've been talking to them quite a bit, is they're also looking at us as being kind of the vanguard of some of these positive changes that we can bring across the country as well, potentially. So I want to really thank you guys for pushing through this, and I know you guys are super supportive of craft beer in general, so thank you guys. And like I said earlier, you know, I think our stance on this is more formological than anything. So if you guys had support, but with modifications, you'd see a lot more of that kind of thing. You know, and obviously the big thing too is what we've been talking about today, and part of the reason we kind of came hot out the gate with talking about the dual assignment and all the rest of that kind of stuff is because that's what we want, and that's something that we think that will really move our industry forward in a positive way. Because again, and the other thing too, just to be on the record, our wholesalers are awesome. I'm not gonna lie, I self-distributed for like 9 years, carrying a half barrel keg down a rickety flight of stairs into somebody's basement. You know, my back is, you know, not what it once was because of that. So I'm super grateful to the distributors who can do these kind of things for us and really kind of get product out there. But what we're finding again is just that there's no way for us to hold them accountable in case that they're not fulfilling their end of the agreement, which is why we're, you know, having this conversation.
So language is important, right?
Yep.
You say the word dual assignment. When you say that, I think saying, I don't know what, you're in, where's your brewery? What
We're
county?
up in Northeast Connecticut.
So when I hear the term dual assignment, it makes me think that you could give your beer to multiple beer distributors within the county. That's how I look at it. I think the proposal as written was allowing the brewery to do a little bit of self-distributing along with a wholesaler.
Yeah, absolutely. And that would be something that we, would be open to exploring. It's just, again, I think a lot of it just comes down to verbiage. And I think the other thing too, part of the reason why you've seen kind of a visceral reaction from our members, and I know I've been on the phone with a lot of them over the past few days, they're scared. Craft beer has been hit really hard over the past couple of years, especially post-pandemic. And it's been a really tough industry in a lot of different ways. And part of the reason why we're, putting so much urgency on this is because, we have the ability to sell product and it's just not getting out there. And so as an industry, we're, it's adding kind of insult to injury in some ways where,
I hear what you're saying. Listen, I'm not trying to be argumentative, just conversational, really. But if the beer sales are down 30% across the country, I mean, are we using the wholesalers as a bit of a scapegoat because maybe beer sales are down 30%? So you might want to get out of your contract with wholesaler A because you're not selling as much. But what if, according to your own, I remember when we met prior to this, according to your own figures, the certain IPA, certain beer sales are down across the board.
Yeah, there's definitely a decrease in craft beer in general, but you can get into a chicken and the egg kind of conversation about that too. And especially in Connecticut, one of the things that we're finding with a lot of accounts is they have, and again, the distributors have decreased the number of, we do have metrics on this. They have decreased the number of stops that they make and the number of like sales reps visiting different places. So, and as a result, our sales are down. So there's an element of them, and I understand from a business perspective, I am a business owner too, when they're trying to save money and make sure that their bottom line is getting met. And so they're trying to find different ways to make sure that that's going to work, which means inevitably that they're going to decrease that. But it's unfortunately causing us the most issues too, because then it means that, and the other thing too that hasn't really been talked about is the fact that there's a lot more pressure from outside states and bigger breweries that we don't have the clout and ability to kind of deal with, where if AB InBev comes in and says, you have to sell X amount, they're going to take priority, especially when we only represent, 2 to 6% of total sales in the state. So when they have to meet minimum orders with the distributor, we have no option but to just get shunted down the line. So that's part of the issue too, where craft beer, beer sales in general might be down, but we're at the bottom end of the totem pole. So they're just pushing us out of necessity for that.
But based on the way our two things, I think the minimums have to do more with, the price of diesel and labor and all that other stuff. Listen, it's just the way of the world. But when you say like InBev comes in, right? They essentially own the franchise though. So they're putting pressure on their exclusive distributor in that marketplace. So I think I always thought the craft beer, the sales in Connecticut was sort of consumer demand. The consumer demanded it. The customer wanted these local products. So the wholesalers wanted to get in on that and they were compelled to do it. Right. So if InBev comes in and, they go to DiCello and say, listen, you need to sell this, and this, they're kind of sort of talking. It's almost like a Ford dealer telling a Ford manufacturer telling the Ford dealer, you got to sell more Fords.
Yeah.
Right or wrong.
No, I see what you're saying. The issue is ultimately is that, again, we're, I think the fact that we're just so small is the main issue, where we're just at the bottom of the totem pole. And I know from talking to distributors that we just signed on about a year ago with our distributor, who again is fantastic. I'm super happy with them, but we still run into issues all the time because, and they say, hey, you're at the bottom of the totem pole. So I think that's, even though they, I know we're asking them to do something outside of their realm is what you're trying to get at. It still behooves them to sell product and to make a profit and get our product out there. So that's why it's kind of, frustrating on our end, because there may be another distributor out there that could and really wants to sell our product that, but we just, don't have a system in place to be able to hold them accountable and move to another scenario.
So I won't belabor the public hearing, but I would be interested to hear from your perspective what you think would be a resolution, a fair resolutions to back out of a contract. You would think that when you sign the contract, the breakup clause would be in there already, and not really in statute. I think the chairman probably shares my concern is I don't understand why we do it anyway, because you're entering a contractual relationship with a wholesaler. You could sort of put the breakup clause, most business relationships have the breakup clause written when everybody's getting along. Right? I mean, that's just how it works. So I don't know why you guys, our industry, the industry, can't do that when they sign on with the beer wholesaler, just like they can't, like the suggestion of cutting out Mystic, or I'm going to keep my own 5 mile radius, or I'm going to keep this label, but I'm giving you this label. I find those all reasonable negotiating things. I understand why you sign on with a wholesaler. Listen, I was fascinated when we learned about this more. You know, you don't become just a brewer when you self-distribute. You're a collector, you're a delivery, you're a salesperson. I mean, accounts receivable probably is the most annoying thing on the planet, right? Let's be honest.
Amen.
So now you're trying to sell your beer to people that owe you money. And now, so you got to call them and say, hey, you want another keg? But, oh, by the way, I need a check. You're in a tough spot. So I didn't know if there was a specific thing, one that maybe the wholesalers wouldn't be so crazy about, but is a reasonable thing for you guys to find relief.
Well, I think overall, so even in a lot of wholesale agreements, you will find like breakup clauses, as you said it. But the issue is that state law supersedes that. So regardless of whatever, and there have been instances that I know of where it has happened, where breweries and distributors have been like, hey, look, this isn't working for either of us. Usually it'll end up being where the brewery will have to, again, buy back the stock of whatever they had that was sitting in, you know, their cooler space or whatever else like that, which is obviously, you know, not ideal, but they still were able to get out of the contract to do it. I know of a brewery that happened to probably about 1.5 years ago here in Connecticut. So it is in theory possible, but our issue, and I think, you know, all of you guys have heard about this, and part of the reason why we're appreciative of your general support on this is that, you know, why is the state getting involved in contracts? To utilize the example that one of the wholesalers brought up the other day, like craft beer, or earlier today, craft beer needs to stay in its lane. You know, why can't you get a you know, spare rib at an Italian place? Well, you know, if the state had mandated laws about, you know, between the spare rib wholesaler and the restaurant, then, you know, that would be a thing, you know. So you know, let's have more of that kind of situation where we can do what we need to, and that's ultimately what we would like to have happen.
So I think we could talk offline, but you might be conflating. When he says stay in your lane, I think he's referring to something different. A manufacturer gets to operate on all 3 tiers of the 3-tier system. It's sort of a slightly unfair thing. And that's where some of the stress came in, which I believe we addressed in 2019. It's this one issue you're talking about now that we haven't fully resolved, and that, to be blunt, the chairman has been working on since he's been on the committee. Do you know of, and you may not know the answer, and I could get it another time, does the same return rules work for all the products that your wholesaler sells, or do they just do this with the craft local people? Like, you know, listen, if a Budweiser distributor has a whole bunch of Bud that went bad, do they get to charge back that manufacturer? And do you know any stats at all? Because your industry.
So I can't comment on that. I do only know for craft beer, to be frank with you. So, but that is something I will look into, and all the rest of it, because that is a big concern. That being said, though, is the amount of power that you know, especially the out-of-state entities have in regards to pushing this product through. Is like, that's one of our issues, is that they have a lot more ability to say, hey, look, our product is about to expire. You need to, you know, make sure that this moves before it goes bad, kind of a thing. You know, and so we get shunted down the list as far as products that are pushed out there. So, and again, with the minimum orders and all the rest of it, it complicates things a lot further.
Well, I appreciate the conversation. I think we can go on for a while with it, but I'll stop there because I have access and we could talk offline. But I really appreciate your thoughtful answers, and that you are a wealth of knowledge. And it's an interesting topic that I'm sure will continue.
No, and thank you guys again so much for your time. If you guys want to have a real snoozer, I can also send you guys for my class. I always have a pro distribution and a pro self-distribution kind of panel. So I invite people from the industry that self-distribute and people that work for distributors to kind of talk about the pros and cons of each kind of scenario. and the benefits. And then the assignment at the end of it is that they have to decide whether they're going to sign with a distributor. Real quick, 95% of my students don't sign with a distributor, just FYI. So they just give you an idea of what that looks like at the end of it. So, but thank you guys so much for your time. I really appreciate it.
Great. Are there any further questions online?
Not
No,
online,
Thank you
Mr.
very
Chair.
much for your testimony.
Thank you so much.
All right, is there anyone else in here who hasn't signed up who would like to testify? MJ, anyone online? Okay, so we're adjourned. All right, this public hearing is adjourned. We will see you on Thursday. Thank you.